Please be seated. Good morning. We're back on the record. Case number 12 CF 1083, State versus George Zimmerman.
Good morning, Your Honor.
Good morning. Fine. How are you? Good morning. Are we ready to bring the jury in?
Your Honor, I have one matter that
Yes.
I would just like to review. Your Honor, as the court is well aware, we did file a motion in limine to exclude improper opinion evidence, and we have felt at certain points, and I know we've addressed it already before the court. I know there's a motion in limine that the court granted. I wanted to provide the court with some case law, additional case law on that subject matter. The two cases I want to cite to the court are Jackson v. State, found at 107 Southern 3rd, 328, and then also Tumblin, Tumblin, found at 29 Southern 3rd, 1093.
Thank you.
And I'll give the court a minute to. I've highlighted the pertinent part. It's on Jackson, it is on page 13 of the opinion, under head notes 3 and 4.
Could we set some time to address this? It's not right in the middle of my cross-examination, because I've just now seen the cases and don't even have the motion in front of me.
Well, the motion had been filed and ordered on. This is just the case law. Let me take a moment.
Case, it's on pages 10 and 11 of that opinion. Okay, I have read both of the cases. What yesterday when we were up at the bench, there was specific objections, and we read back the testimony. So, what is the specific objections? The latter part of the testimony of Detective or Investigator Serino, Mr. O'Mara was asking the investigator specifically to comment in terms of the truth or veracity of what the defendant said or didn't say, and that's improper. And so he is asking investigator, and did elicit from Investigator Serino opinions as to the truth and veracity of what the witness said, which is totally improper. Under the case law and under the motion we filed previously, we would ask the court to strike that and have the jury disregard that.
Okay, do you know specifically which questions and answers that you're objecting to?
I think it was towards the very end, and I can ask the court reporter.
If you'll take a moment to look at that, and then you can allow the court to know.
Just sort of in a recess, I'm going to cue up the audio because I want to use it across, so it's going to make some noise. Is that all right?
Yes, sir.
In order to show him that I have to go
Almost the last question was, and I can just read it well.
Okay, go ahead and read it. We'll still off the record.
It states, so if we were to take pathological liar off the table as a possibility just for the purpose of this next question, you think he was telling you the truth? Yes.
Okay, response? Now we're back on the record. Let me know when you're there.
Okay, thank you. Hold on. Okay, go ahead, thank you.
I would ask that I be given some time not only to review the state's case law, but to come up with my own to respond properly, rather than trying to do it now, since I've just now truly haven't even read those. To the extent that you want at least a partial response right now, this is the chief investigating officer who was interviewing the witness and who himself took on a challenge interview to attempt to identify whether or not this witness was telling the truth or not. Within the context of a challenge interview, within which the whole premise is to determine veracity or truthfulness, I think that since this person took that on, then he can now tell what he believes to be the result of that context interview.
I'll give you a moment to read Supreme Court Florida case Tumlin, TUMBLIN versus State, found at 29 Southern 3rd, 1093. decided in 2010 under Head Notes 9, 10, and 11. I'll quote, allowing one witness to offer a personal view on the credibility of a fellow witness is an invasion of the province of the jury to determine a witness's credibility. It is clearly error for one witness to testify as to the credibility of another witness. Moreover, it is especially harmful for a police witness to give his opinion of a witness's credibility because of the great weight afforded an officer's testimony. Police officers, by virtue of their positions, rightfully bring with their testimony an air of authority and legitimacy. A jury is inclined to give great weight to their opinions. And then another case holding that police officers' comment that witness was credible and positive in her pretrial lineup identification was error requiring a new trial.
I guess my concern, and I'll take a moment to read it, is that in that context, it was a question of affecting the client's right to a fair trial, because in effect what happened in the Tumblin case was the officer vouched for the credibility of an eyewitness who came in and said, I'm certain that that's the defendant. And then the cop came in and said, well, I'm certain that I believe her when she says, I think it's him. That's affecting my client's right to a fair trial. I think it's a much different perspective under the facts of this case. Now, again, I need to read this and also get some case law, but a quick response is, it's a question of whether or not my client's right to a fair trial is being affected. I don't think the same would apply to the state when it's the state's own witness who presented a conflict or an attack argument to my client and he successfully responded. But if I might have a moment to review it.
Mm-hmm.
Your Honor, while that's going on, I do have one other matter that I wanted to address with the court.
Okay, well, we can do that.
It's controversial as
Okay, well, just one second. In the Jackson case, which is also Supreme Court of Florida, 107 Southern 3rd, 328, decided November 2012 under Head Notes 3 and 4. Generally, a witness's opinion as to the credibility, guilt, or innocence of the accused is inadmissible. Allowing one witness to offer personal view on the credibility of a fellow witness is an invasion of the province of the jury. Cites to the same cases, but in this case it was the opinion as to the credibility, guilt, or innocence of the accused.
Correct, so not given by a police officer, an adverse witness. That was another witness where it
Well,
was
if you read further down, it cites to Pausch, P-A-U-S-C-H versus State, 596 Southern 2nd, 1216, that holding that admission of officer's statement expressing his disbelief of the defendant's story and accusing her of lying and committing the crime was reversible error.
Again, I don't think that's the facts that we have here.
Well, because they're opposite. He's testifying as to the truth and veracity of your client's statement.
Okay. Just need a moment to
Go right ahead.
Just a quick review. I understand the court's concern. I'm sorry.
Go ahead.
A quick review. I understand the court's concern, but I really would like an opportunity because all of these cases are where that testimony is coming in against the defendant, and it's a question of whether or not that affected the defendant's right to a fair trial. I think that it may well be different, but I just want some time to look to see if this case law where a chief investigating officer who has to determine where the investigation is going, determine whether or not to continue to investigate, determine whether or not what credibility to give to certain witnesses and how to resolve differences between what one witness may have said happened to the other witness. Within the context of that officer's investigation, what he said was, as I was going through the interview, I challenged him, and his response suggested that he was telling me the truth. I just want an opportunity to see if
Well,
there's
but you asked him a specific question. Was he telling you the truth?
I said, did you think he was telling you the truth? Yes.
Well, it's the same difference.
Well, again, I understand the court's concern and the state's objection, but within the context of an investigating officer charged with the responsibility to make exactly those determinations, whether or not he believes him, whether or not he's going to arrest him, whether or not he's going to charge him, whether or not he's going to believe one witness over the other, that is exactly what an investigating officer has to do in the context of his investigation.
And if the question would have been answered, no, I thought he was not telling the truth?
And it would be out there.
Your Honor,
He could have asked it that way. He could have answered it that way.
Your Honor, our position is that these cases are right on point. The state is also entitled to a fair trial, and these cases are right on point as to this issue. Mr. O'Mara, on behalf of this client, cannot claim that because the officer said, his belief at that point that he was telling the truth, that should be admissible. As the court noted, if the defendant has said he's a liar, or in fact, I believe he's guilty because ABC and all that stuff, that's improper. And we had filed a motion in limine that the court heard back in May. The court ruled on it and granted. And I think the rules should apply, the law should apply to the state and to the defense.
Okay, do you have a suggested curative instruction?
I would ask the court, read that, have the court reporter read it or read it back, whichever way, and then ask the jury to disregard that and that is improper comment by a witness as to the truth or veracity of another witness, in this case, the defendant.
Anything else?
No, Your Honor.
Is Detective Serino here? Oh, you had another matter you wanted to take up?
It pertains to a potential witness for later in the day, that being a Professor Gordon Pleasance. Your Honor may recall the state last week or a little before had filed a motion to perpetuate his testimony due to his being unavailable. That was heard, objected to, and granted. We scheduled the deposition to perpetuate for the last night that he would be in town, which was, I think the motion was granted on a Monday morning, and he was set to depart Wednesday morning, so we set the deposition and noticed it for Tuesday night. Everybody showed up except the defense, and I communicated with counsel for defendant on that night, and basically I think it was just a matter of people forgot about it in all the rest of things that was going on, and I understood that, but my problem was, and I explained this to them, that the witness wasn't available to reschedule because he was having to be at the airport in the morning and fly out and was going to be essentially unavailable. So I proceeded to at least preserve the direct testimony on videotape and a transcript, both of which have been provided to counsel. The witness indicated that there would be sporadic availability perhaps for video conference type testimony. He is traveling through the New Mexico desert, I believe, on kind of a hike, and is occasionally reachable by cell phone, or if we leave a message when he gets to a next destination, sometimes he can find enough service to call. Yesterday I managed to reach him via that method, and Mr. West informed me last night that they were not going to be stipulating or agreeing that the perpetuated testimony could or should be admitted, and therefore they wanted the witness, if he was going to testify, to have to do so, I guess, by video link or some other such. He is not available to do that today for sure because he is in transit, he said, across a couple different states and given the environment. He may, once he arrives tonight, be able to locate a place to be available tomorrow morning, even though he's a couple time zones away. But he can't guarantee me that. He just believes that that would be likely. So I wanted to, number one, bring that to the court's attention. Number two, hear how the defense would propose that we handle that situation or issue if there's an objection to what's potentially playing that videotape, and get that out of the way now before we run into it this afternoon when we want to call a witness.
Okay. Response?
I'm not quite sure what the proposal is. I think it's to play the video of Mr. Pleasant's direct testimony and then not afford the defense an opportunity for cross-examination. I don't know if that's it. That, of course, is completely unacceptable. If Mr. Manti seeks to offer the witness's testimony through Skype, then he should offer the direct, and then we can cross as appropriate. We also need an opportunity, though, to speak with Mr. Pleasant's prior to him taking the stand by whatever method that he does. The motion to perpetuate, as the court's aware, was a last-minute motion during the course of the trial when the state realized Mr. Pleasant wasn't available. We don't fault them for the effort that they made. We didn't become aware of the significance, frankly, if any, of this witness's testimony until, as well, sometime after the trial started, when we began to realize why he was being offered in connection with Mr. Zimmerman's coursework. I think Mr. Pleasant may have taught an online course at the Seminole State College. In any event, the issue last Tuesday was a scheduling complication. I don't dispute that the deposition was set sometime after court on Tuesday, and that at some point may have known that. There were no reminders or any conversation during the day, and then at the end of the day, when Mr. Manti had set up the video deposition with Mr. Pleasant here and contacted me by phone to say, "Where are you?" At that point, we had already left the courthouse, but more importantly, Mr. Zimmerman had already been escorted off the property. A motion to perpetuate testimony either requires the accused's presence or a specific waiver, and we were unable to accomplish either of those at that moment. I apologize to Mr. Manti, and here we are today. As the court's aware, we've been working full days and then some, and of course, there's lots of work to do at night and on the weekends. With this witness's unavailability, I think we should target when he is available, give us a chance to talk with him, and schedule his testimony by Skype if he's otherwise allowed to testify. We have no objection to that. We have no objection that the court place him under oath as opposed to him being in the presence of a notary, wherever it is where he testifies. And we have no objection if at some point when he testifies it's out of order.
Okay, response?
I guess my response to that is twofold. If we're discussing waiver, the state's position is, we had the argument on Monday. The court was pretty clear in its ruling. I think we were all pretty clear on the reason that we had to do it was because the witness was leaving before we would actually have the opportunity to start trial and present his testimony. And that's the reason it was set when it was. So from the state's position, number one, for whatever reason the defendant and his counsel didn't show up, we think that should constitute a waiver of the right to presence. Simply not coming isn't really a reason to bar the direct testimony. My counter-proposal is that we play the direct, and there was one exhibit that he identifies during the direct and that I intended to introduce. Play the testimony of the direct, introduce it, and if counsel wishes to cross, then hopefully he would be available tomorrow, but I can't, obviously I said, I can't guarantee that given the locations and places, and that's the reason we moved to perpetuate in the first place. And if they want to cross at that time, that's fine. I'm not attempting to deprive them of the opportunity to completely to cross.
Well, there's a lot of different scenarios that could play out here, and if you could find out sometime today what his availability would be tomorrow. Let me table this argument till this afternoon.
Yes, Your Honor. Thank you.
Okay, thank you. Is there anything else? Let's get Officer Serino in here, please. And Shelley, can you queue up to that last question and answer? Are we ready to bring the jury in?
Yes, Your Honor. Thank you.
Okay, let's bring them in.
Just that one question.
That one question and answer, yes. I think it was like taking the hypothetical out of it. Please be seated. Shelley. Just one.
Ready?
Okay. Good morning, ladies and gentlemen, and welcome back. During the overnight recess, did any of you have any discussions with each other or with anybody else about the case? No hands are being raised. Please raise your hand if your answer is yes to any of these questions. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use an electronic device to get on the internet to do any independent research about the case? People, places, things, terminology. No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you. I'm going to have the court reporter read back a question and answer from yesterday afternoon and give you an instruction on that. Shelley, you may do so.
Question was, so if we were to take pathological liar off the table as a possibility, just for the purpose of this next question, you think he was telling the truth? Answer, yes.
Okay, ladies and gentlemen, my instruction to you is that that is an improper comment by a witness as to the truth and veracity of another witness, and you are to disregard the question and the answer. Thank you very much. Mr. O'Mara, you may proceed.
Morning, officer. How are you?
Good morning, sir. Fine, thank you.
When we were talking yesterday before break, we were talking about the we agreed to use the term challenge interview, correct?
Yes, sir.
And we were talking about the context of that challenge interview, right?
Yes, sir.
Some of what you challenged him with in the context of that interview. I want to back up a little bit. I mentioned yesterday as an example that one technique that law law enforcement officers are trained to use is what I call a command voice, and of course you're familiar with that, right?
Yes, sir.
That's when you basically have to take control of a situation and you say it in a stern voice, almost a yelling voice, because what you want to do is let everyone know you're the person in charge, correct?
Yes, sir.
In that context, you're not actually yelling at the person like you're angry with them, are you?
No.
It's a technique to gain control of a situation, correct?
Yes, sir.
Similar in the challenge interview, it's not as though in this context you're actually angry with Mr. Zimmerman, correct?
No, anger's not a part of it. No.
Right. It's just a technique or a tactic that you use to try and undermine his confidence in his own story so that you can see if he breaks, correct?
Yes, sir.
And that's the purpose of it, correct?
Yes.
Okay. So that when you challenge him, in an example, you said to him, you sound kind of frustrated on the phone conversation, because everyone's going to hear these things, you know. What was your purpose in that?
On which phone conversation? On which phone conversation?
I presume, having read the entirety of your interview, that you're talking about how he sounded on the non-emergency call.
Okay.
And was that in an attempt to sort of, again, undermine his confidence in himself so that you might get some movement in his story?
Not necessarily. I mean, it could have been.
Okay.
I'm not quite certain my comment might have been or what tone I might have used.
Okay. Would you then defer for the jury's consideration to the way you present to yourself in the challenge interview rather than just me going over or repeating it in sort of bare words?
Yes, sir. Yeah.
But you agree that your purpose was to challenge Mr. Zimmerman
It could have been, yes, sir.
and to try and undermine his confidence in himself such that he might tell you more or change his story in some way which would then give you an opening, correct?
I would classify it more trying to extract truth if he's hiding it, yes, sir.
Sure. And did you extract any truth or anything, any change in his story through this technique?
No, sir, I did not.
He was, in fact, consistent throughout, correct?
Yes, he was.
And he was also consistent with both all of his prior statements, correct?
To my knowledge, yes.
Okay. As the chief investigating officer, you had availability of those prior statements, correct?
Yes.
And there were some changes. I think you said yesterday there were certainly some expansions and even some minor inconsistencies, right?
Yeah, there was some variations of accounts.
But nothing that you considered significant.
Nothing major, no.
Nothing that evidenced to you that he was lying to you?
Objection, Your Honor. It's an improper argument.
Sustained.
Any inconsistencies that you consider to be significant?
None which I can challenge him with, so I would say no.
With some help, hopefully this will work, I'm going to play with you a portion of the tape that you heard yesterday. I understand that I'm going to play it. If you can't hear it, I'll play it a second time. I believe this is a part to focus you on the investigation where you are playing for Mr. Zimmerman the 911 call, which has the screams in the background, to put it in context. And I'm going to try and get the volume correct, Your Honor, so I may need a couple of tries. Oh, I'm sorry. It is 182. It is the...
Okay. And is it a male or female?
It is a male.
And you don't know why? I don't know why I'm yelling out, but I don't.
Did you hear Mr. Zimmerman?
I'd have to hear it again.
Sure.
Keep them up.
I'm going to keep it low, Your Honor, until we get back to that point.
But now we're here working for you here, okay? Now that's where you gotta open your mind, okay? And if there's anything that needs to be changed.
Your Honor, I'd ask that it be played
I'm
at the
sorry.
same level so that the jury can establish the
I
context.
think he's just trying to
I'll
cue it
do that,
up.
Your
I
Honor.
can't do this anymore, yeah? Let's play this one.
911, you need police, fire, medical. Maybe
Hear that voice in the background?
both. I'm not sure. There's just one script. 911. Do you need police, fire, medical? Maybe both. I'm not sure. There's
That's
just
you.
one screaming out.
In the transcript, and I think it was pointed out on 2 occasions by Mr. DeLeonde yesterday that there was a suggestion that Mrs. Zimmerman said, doesn't even sound like me. Do you remember that?
Yes, sir.
Now, is it your opinion? Well, your opinion. Did you interpret that Mrs. Zimmerman was denying that it was him, or just that it simply didn't sound like him?
Your Honor, I'm going to object as to having this witness testify about what the defendant was thinking based on what he said.
Okay, sustained.
Did that change the direction of your interrogation of him, that statement that he said, doesn't even sound like me? Did that change the direction of your interrogation of him at all?
No, it did not.
Did that cause you any concern whatsoever?
No, it did not.
If I might just have a moment, Your Honor. I want to make sure that I get the right portion of the tape. And I think I might need to just play it a moment more. So I'm going to do that now, and it may be on that portion.
Guard. And what's the address that they're near? 1211 Twin Trees Lane. Twin Trees Lane? Is this in the Twin Lake Homes in Sanford? Yes. Okay. And is it a male or female?
Are you hearing
It was
yourself?
a male. And you don't know why? I don't know why I'm yelling help, but I don't know. Send someone quick, please. Okay. Does he look hurt to you?
Did you hear it then, in the background?
What he said?
Yeah. Nonetheless, you heard it that night, correct?
Yes.
And you heard his words being, does it even sound like me?
Yes.
That didn't change what you did as far as the investigation?
No, it did not.
Similarly, in the challenge interrogation, you even told him that you were moving from the interrogation room to another area out by your desk as well, correct?
Yes, sir.
That was both to listen to the tape, correct? But to also change the setting for him?
No, exclusively because of the facility. I didn't have any of. I didn't have a computer inside the interrogation room.
Okay. Now, you said in response to a question from Mr. DeLeonde yesterday that you perceived Mr. Zimmerman's injuries to be minor, correct?
Yes, sir.
And that was as you looked at him that night after midnight, correct?
Yes, sir.
And we showed you the picture of his injuries before he was cleaned up, correct?
Yes, sir.
Did he need to have any injuries at all for you to look into the investigation concerning both the crime and any possible defenses?
No, sir.
That's not an element, is it?
No. As far as him having injuries, no.
And you saw him on the 27th after midnight, correct?
Yes, sir.
And then he went to work the next day and then saw you for the 27th in the afternoon for the recreation or the recreation video, correct?
Yes, sir.
And then he came back to talk with you again voluntarily on the 29th, correct?
That's correct.
And did you talk to him after that?
Yes, we had conversations.
And that was over the phone?
Yes, sir.
Did you talk to him again in person?
Not that I can recall.
When you spoke to him on the phone, that was in order to, again, sort of forward your investigation of both the crime and any defenses to it, correct?
I believe he contacted me, but yes, the ultimate goal would have been to forward the investigation.
And in all of his communications with you, even after the 29th, he was cooperative?
Yes, he was.
Answered whatever questions you had for him?
Yes, he did.
Presented himself to do whatever it is that you wanted him to do?
Yes, he did.
You have done even more than just take the interviews of my client as part of your investigation in this case, correct?
Yes, sir. From other aspects of the investigation, yes.
Met with other witnesses?
Yes.
You met with Tracy Barton, correct?
Yes, I did.
At your office?
Yes, there and at his residence also, or at the residence in Twin Retreat View. Yes.
Why did you meet with him at your office?
I'm object is beyond the scope of direct and calls for hearsay too.
Well, actually,
Okay, let me take one at a time. It was not covered in direct. It's not hearsay, the question and the answer that it would elicit. I have to sustain on wasn't covered in,
may I respond?
yes, you may.
I would just allow a little bit of leeway for this, the chief investigating officer in the case, to ask him what else that he has done in doing exactly his duties.
Well, you could do that in your case.
So
If
I
you
will
choose
call
to do
him
so.
as my witness,
If you choose to do so.
then I will do that. Thank you, Your Honor. And I need to get this back to the clerk. If I can just have a minute, you going to use it?
Not right now.
Redirect it.
I actually do know how to use a laptop on occasion. Thank you very much.
Good morning, sir.
Good morning, sir.
I'm not going to ask you to the opinion of anybody or to guilt or innocence. You understand that's improper, and I can't ask you that.
Yes, sir.
My question is,
Let me object, Your Honor, as to that non-question of this witness. Nothing but a comment on your previous ruling, which is inappropriate.
Okay, sustained.
Mr. O'Mara, on behalf of the defense counsel, asked you some questions about anger and disdain. Do you remember that, about ill will, hatred, all that stuff?
Yes,
Do you
sir.
remember him asking you a series of questions regarding that?
To somewhat, yes, sir.
Okay. Specifically asked you about your interview with the defendant, that you had reviewed it, and also Investigator Singleton's interview, and whether you found any evidence of hatred, spite, anger, disdain, ill will. You recall a series of questions regarding that?
Somewhat, yes.
Okay. I want to play something for you, sir, if I can figure out how to do this.
Just use this drop down.
Okay, got those them all there. Oh, okay. Our first play from you from the non-emergency call that defendant made.
Okay. These assholes, they always get away.
Is that something you would use in reference to somebody that you're going to invite over for dinner? Would you call them these assholes?
No, sir, I would not.
Does that seem like to you like a friendly comment about somebody else?
No, sir, it's not.
Okay, how do I do it again now? I gotta hit this.
Yeah. You go straight in, don't turn and make a left. Shit, he's running.
He's running? Which way is he running?
Down towards the other entrance of the neighborhood.
Okay. Which entrance is that he's heading towards?
The back entrance.
Did you hear that last comment the defendant stated, and pardon my language, these fucking punks?
Yes, sir.
Okay. Is the word, pardon my language again, fucking punks, something that you would refer to, something good about people when you reference them?
No, sir, it's not.
Are you saying, or you did testify when you were cross-examined, that those two, these assholes always get away, and pardon my language again, these fucking punks, that he said that because he wanted to interact and meet and invite Trayvon Martin for dinner that night?
Excuse me, Your Honor, that would be speculation.
Sustained.
Are you saying that those words were uttered by the defendant in reference to wanting to meet the victim?
Excuse me, Your Honor, that would be speculation.
Okay,
I'll be glad to rephrase it.
sustained.
Does that not indicate ill will, hatred, and spite against somebody else, sir?
No, it does not.
In your opinion, calling somebody, reference them as, pardon my language, fucking punks?
That is ill will and spite.
It
Correct.
is?
Yes.
Okay.
Are you following him?
Yeah.
Okay, we don't need you to do that.
Okay.
All right, sir, what is your name?
Sir, you were asked by Mr. Romero on behalf of the defendant in terms of whether there was evidence that he had followed him or not. Do you recall being asked that?
Yes, sir.
And do you recall you, in fact, to use Mr. Romero's words, challenged the defendant regarding that? Do you
Yes,
recall
sir.
that?
Yes.
About whether the defendant was following him or not? You
Yes, I
recall
did.
that? Did you hear the word there by the non-emergency operator about whether he was following him or not?
Yes.
And did the operator not tell the defendant not to do that?
In so many words, yes.
Okay. In your interviews and review of Investigator Singleton's interviews,
Would you mind taking that off the screen?
sure. Sorry. In your interview and review of Singleton's interviews, did the defendant, in your interviews of him too, did he ever say he was excited? You want me to rephrase it? I'll be glad to rephrase it. I apologize. In your interview and also your review of Investigator Singleton's interview of the defendant, which you've had an opportunity to do, correct?
Yes, sir.
Mr. Romero asked you about those. And did the defendant ever indicate that he was happy that there were burglaries being committed at Retreat at Twin Lakes?
No, he did not.
Did he ever say he was excited that his neighborhood was getting burglarized?
No, he did not.
In fact, didn't he say this, sir?
950. This is the correct one? So you live at 1950 Retreat View Circle. Okay. I'm just gonna keep quiet and you tell me the story. You tell me what happened tonight, okay?
Just tonight?
Yeah, or whatever led up to this. Anything you want to tell me about what happened and why it ended up, what it ended up to where this boy got shot. Okay.
The neighborhood has had a lot of crimes. My wife saw our neighbors get broken into and she got scared.
Okay, you're talking about the residents or vehicles?
The residents.
Okay.
While it was occupied. So I decided to start a neighborhood watch program in my neighborhood.
Okay, what is the name of the neighborhood?
Retreat at Twin Lakes.
Now, Investigator Singleton asked the defendant what led up to this in terms of the shooting, correct?
Yes.
And that's how you replied, correct?
Yes, it is.
Watch
Neighborhood watch, okay.
with Wendy Dorval, Sergeant Hertz, and Officer Buchanan, and I'm the coordinator. And there's been a few times where I've seen a suspicious person in the neighborhood. We call the police, the non-emergency line, and these guys always get away.
Okay. What made them suspicious?
You recall hearing that in terms of Investigator Singleton asking him, the defendant, about what was going on, and he's stating, as he stated there, that they always get away? You
Yes,
recall
sir.
that?
Yes.
Didn't he say that to the non-emergency operator also? But he used more colorful language, pardon my language. He used, "These assholes always get away," correct?
Correct.
And those words were uttered within minutes of the actual shooting, weren't they?
Yes, they were.
I had called before, and the police had come out, but these guys know the neighborhood very well, and they would cut in between buildings and lose.
You're saying these guys, who are these guys?
The people committing the burglaries.
So you've seen more than one person, like, looking suspicious and doing these burglaries?
Yes, ma'am.
Okay.
Now, Investigator Singleton had him clarify when the defendant in that interview on the 26th stated these guys, he had him clarify or describe what he meant, correct?
Yes, sir.
And defendant said the people committing these burglaries, correct?
Yes, sir.
And then to the non-emergency operator earlier that evening, when he spotted Trayvon Martin, he made reference to, using more colorful language, pardon my language, "these fucking punks," correct?
Correct, sir.
So when Mr. O'Mara asked you about profiling, isn't it accurate that he was profiling Trayvon Martin as a criminal? He assumed that he was a criminal that night?
The object, Your Honor, that call for speculation.
Sustained as to speculation.
Do you recall Mr. O'Mara asking you about whether he was profiling the defendant, Trayvon Martin?
Yes.
Okay. If somebody were to believe that another person is a criminal, could that be a form of profiling?
The object, Your Honor, that would be either speculation or irrelevant.
Overruled.
If I were to believe that you're a criminal and I followed you and did something, wouldn't that be profiling you?
Then I would object based upon improper opinion testimony unless we're opening that door.
He can testify if he knows in his experience as a law enforcement officer.
As long as we're going to his opinions, fine.
Let me make sure it is clear. If I were to believe that somebody was committing a crime, could that not be profiling that person,
Object,
believing?
Your Honor, leading.
Overruled is deleting.
Do you understand my question, sir?
Yes, I do. It could be construed as such, yes. Construed as such, yes.
Your review of the evidence there, was there any indication that Trayvon Benjamin Martin, the young man, I think 20 days past, had just turned 17, was committing a crime that evening, sir?
No, sir.
Was there any evidence that that young man was armed?
No, sir.
You were asked by Mr. O'Mara several times, and I think he made reference to your last interview being a challenged interview, I think. I don't know if you completely agreed with him on that or just agreed to use his terminology for that. Did you agree that that was a challenging interview?
I wouldn't quite classify it as that. However, it could be viewed as a challenging interview based on his view of it.
Okay, his being Mr. O'Mara's?
Yes.
Okay. Let's assume for purposes, let's call it a challenge interview, but you know what I'm referencing to?
Exactly.
Your last interview with the defendant on February 29th.
Yes, sir.
Okay. And Mr. O'Mara asked you whether there was inconsistencies or not.
Yes, sir.
Okay. And I want to play certain parts of you where I believe you at least questioned him about whether he had said something inaccurate before or said something different. Do you recall that?
Yes, sir.
And I want to ask you about these, if I could.
Okay, just let me know if he does anything else. Okay? Yeah, we got him on the way. Just let me know if this guy does anything else. Okay. These assholes always get away.
That statement. These assholes. It's behind that.
People that victimize
recall you playing that recording for the defendant and asking him about that? Now, that, somebody may refer that to a challenge, but do you recall questioning about that?
Yes, sir. I pointed it out to him.
Okay. And he made reference to, when he made reference to, pardon my language, these assholes as people who commit crimes, correct?
Yes, sir.
Told me not to follow him, and I wasn't following him. I was just going in the same direction he was.
That's following.
Well, I mean,
If you were
wrong.
okay, so you basically wrote it off. I mean,
Right, and I was on the other side.
Now, you were questioning him, pointing out an inconsistency, weren't you not, that he was, the defendant was claiming he was not following him, and you're telling him, that's following him, correct? You recall saying that?
Yes, sir.
Concern is also this. Oh shit, he's running. And I'm getting out of my car in an instant to make sure I don't lose sight of this guy. That's what it sounds like. Are you following him? Because that's what it sounds like you're doing. That's why he asked you the question. It sounded to the dispatcher likely that you were running. And that's why he asked you that question. Are you following him? And your answer is yes. Okay? But then you get to the other side and you're concerned about walking past this guy when you've already been chasing him, essentially. And he's telling you to go back to your car, and now you want to pretend, or not pretend, you want us to believe that you're concerned about having a flashlight to move back where you just ran?
you're
Trying
looking
to
for
catch up
him.
to him. See what I'm saying?
Okay, it sounds like you're looking for him.
Do you recall you and Investigator Singleton questioning him about that?
Yes, sir.
About there possibly being an inconsistency based on what he's saying and what the evidence showed?
An inconsistency as far as his acts and his words,
Yes, sir.
to clarify.
Right. And by the way, while we're at this point, Mr. O'Mara asked you about videotaping. You recall that you had questioned the defendant about videotaping, and you showed him the victim's camera that was at the scene near where his body was. You recall that?
Yes, sir.
And you stated, I believe, in direct and in cross-examination that you were bluffing him. You were telling him that the victim had potentially videotaped the whole thing?
At that point, yes, it was a bluff.
Is that correct?
Yes, sir.
And you knew that not to be true, correct?
At that point, yes.
Okay, all right. And my point is, and the defendant made a comment like, oh, I hope to God it was videotaped. You recall that?
Yes, sir, I do.
Okay. Now, Mr. O'Mara asked you about stores and other places that have videotapes out there.
Yes.
Correct? Now, the defendant, I believe you've already testified, was head of the neighborhood watch, correct?
Yes,
And
sir.
had lived in that neighborhood for a while, correct?
Yes, sir.
Okay, so he would have been aware whether there was videotaping or not in any of those buildings, correct?
I would assume so, yes.
Okay. And I know you weren't there when it happened, but you would agree that the interaction between the defendant and the victim in this case, the defendant was aware of whether the victim, before he got shot, took out the video and videotaped the defendant, correct?
Object,
Would
Your
know
Honor.
that.
I would object, that would be speculation.
Sustained.
Was there any evidence that the victim, before he got shot, said, hold on, before you shoot me, let me take out my camera and take a picture of you as you're shooting me?
No, there was none.
Was there any evidence that the victim, as the defendant was following him, said, hold on, I got to take a photograph of you so there'll be a record before you shoot me that you're following me?
Object, Your Honor, that was asked and answered.
Overruled.
Was there any evidence that the victim, as the defendant was following him, said, hold on, stop right there, let me take a photograph of you or let me videotape you before you shoot me or before you're following me and then shoot me?
No, sir, no.
And so when Mr. O'Mara asked you about whether the defendant knew that or not, he would have known that, correct?
I would assume so, yes, sir.
So he basically knew you were bluffing, is what I'm getting at.
Objection,
Based
Your
on-
Honor. That would be speculation.
Sustained.
I'll be glad. Let me play another recording for you if I could, sir.
That you're concerned about having a flashlight to move back where you just ran?
You're looking
Trying to
for
catch
him.
up to him. See what I'm saying?
Okay, it sounds like you're looking for him.
You brought a flashlight with you.
Yes, sir.
You wanted to be able to see him.
You want to catch him? You want to catch the bad guy?
It doesn't, that's,
Fucking punk can't get away. Listen, we're outside that interrogation room, okay? We are in a whole different area right here, okay? This is where, you know what I mean?
You were questioning him about what he had said, about the evidence, correct?
Yes, sir.
Is that what you were doing there?
Yes, sir.
Can you recall? At what point the suffocation happened? Prior to you shooting him, he was on you, correct? Okay. And you were able to reach into your holster? Okay. You shot him at point blank range. He was on top of you, right? Yes, sir. And although that young, nobody came out to help you, and I can't pinpoint where you were smothered. That's the problem I'm having. And nobody's saying they saw him smothering you. People were saying they saw you on top of you, but they didn't see about the smothering part. So.
When we're listening to the screaming, it doesn't sound like there's a hesitation for screaming. It sounds like it's continuous. When somebody goes, it's going to stop. But we don't hear it stop.
We don't hear.
You recall you and Investigator Singleton challenged, to use Mr. O'Mara's words, challenging him about whether he was being smothered or not?
Yes, sir.
Okay. Can we please? A moment, Your Honor. You recall watching on direct and then on cross-examination, I believe it was on direct, I apologize, it was, being asked questions about the videotaping, the reenactment?
Yes, sir.
That occurred on the 27th, you recall that, between defendant, where you took him back out to the scene? Do you recall that?
Yes, sir.
Okay. You were present for that, is that correct?
Yes, I was.
Okay. And do you recall that at some point the defendant walking, as he's walking, and he's walking the route where he claimed he went? Do you recall that?
Yes, sir.
Okay. And you recall him at some point saying that he went to look for an address and there were no addresses to the left there because those were the back of the buildings? Do you recall that?
Yes, sir.
Okay. And I'm going to try to key to this point specifically, but do you recall?
I think I told the operator that.
I'm sorry.
And they said, "Are you following?" For a street sign. Right. So I got out of my car and I started walking.
Go ahead.
Oh. I was still on the phone with non-emergency and I started walking.
Okay.
Down this way. And because I didn't see a street sign here, but I knew if I went straight through, that's Retreat View Circle, and I could give him an address, because he said, just give me the address of the house you're in front of. Okay. And there's no address, because this is the back of the houses. So,
Do you recall that testimony, sir?
Yes, sir, I do.
Sir, do you recall?
he said, I don't know an address. And again, they asked me where he went, what direction he went in, and I said, I don't know. And then I thought to get out and look for a street.
Right there on that corner lived Miss Lauer. You recall that?
Yes, sir.
When you get back in the photographs. I want to show you a photograph of the front of Miss Lauer's residence. Isn't there a numerical address right there in the front of her house?
Yes, there is.
Isn't her address 1211? Sir?
Yes, sir.
defendant, no, you stay right there on that photograph. So the defendant in that reenactment, when he's pointing at all the back of these houses where he's claiming he doesn't have an address, there's an address right there staring at him. Isn't that true, sir?
Yes, there is.
That would be leading. This is still redirect.
I'll be glad to rephrase the question. When a defendant turns and points on video to this side where he's saying there's no address because it's the back of the house, right to the right, what is there? Is there a house there with an address?
Yes, there is.
Go to the aerial exhibit. And for the record, that was State's Exhibit 33. Just number 1. And let me show you State's Exhibit number 1. And I'm going to put a close-up of part of that. For the record, State's Exhibit number 1, that's an aerial photograph of the retreat of Twin Lakes, correct?
Yes, sir.
And as you pointed out when you used Mr. O'Mara's words, challenging the defendant in that interview, you pointed out there was only 3 actual streets in the whole neighborhood, correct?
Yes, sir.
And this street the defendant claims he did not know is Twin Tree Lane, which is the main entrance that you come in and out of that retreat of Twin Lakes. And right here I'm pointing to is Miss Lauer's address, correct?
Yes, sir.
So the defendant, when in that interview, claims he did not know this street and didn't happen to see the address here, but specifically did not know this street, correct?
Yes, correct.
Okay. Thank you, Your Honor. You recall also on cross-examination, defense counsel asking you about inconsistencies or consistencies, correct?
Correct.
Do you recall the defendant in the interview that he gave you and Investigator Singleton stating that after he had shot Trayvon Martin said, or something, put his hands up, correct? Do you recall that?
Yes, sir.
And do you recall that he then stated that Trayvon Martin somehow fell on the ground face first? Do you recall that?
Yes, sir.
And do you recall a defendant stating that he put his arms out, correct? Do you
Correct.
recall him saying that?
Yes, sir.
Now, sir, if I may approach the clerk. Do you recall, sir, that one of the first, in fact, the first person that actually came out before the officer was a person named Manalo, Joe Manalo?
Yes, sir. Jonathan.
I'm sorry.
Jonathan Manalo.
I apologize. And may I approach the witness, Your Honor? Showing you State's Exhibit 77. Do you recall that he took some photographs out there?
Yes, I remember those, yes.
And one of them was State's Exhibit 77?
Yes, sir.
And may I publish that to the jury, Your Honor?
Yes, you may.
And you recall in that photograph the victim's hands being underneath his body?
Yes, sir. Yes, sir.
Could someone say that that was inconsistent with the defendant's statements that his hands were straight out, that he had put his hands out?
That positioning, yes.
I'm sorry.
That positioning, as seen there, yes, it is.
In that interview that you conducted, or Investigator Singleton conducted, the defendant didn't say, I put his hands out, and then after I put his hands out, I put him back in, did he?
No, he did not.
I think in cross-examination, you were asked something about exaggeration. Do you recall being asked about that?
Yes, sir.
And do you recall, I think either you uttered it or Mr. O'Mara uttered it on behalf of the defendant, exaggeration. Do you recall what that was about?
Pertains to the defendant's statements
You felt he was exaggerating certain parts of it?
Among other things.
Did you feel, I can't lead you, so
Okay.
did you feel in terms of exaggeration, what did you mean when you said that he was exaggerating parts of his interview?
How I felt, okay, based on,
Okay, no, what I'm getting is inconsistent. I don't want to,
okay.
you were asked specifically about exaggeration. Did you feel he had exaggerated the manner in which he was hit?
Yes, sir. Yes, sir.
Regarding your interview with the defendant on February 29th, was your investigation still ongoing?
Yes, it was.
Okay. Had you, at that point, and even further, had you gotten any results back from FDLE regarding the analysis done of the clothing or anything else regarding that, sir?
No, sir, I had not.
Had you gotten the medical examiner's report or examination in terms of final findings regarding that?
No, sir, I had not.
Had you gotten any results regarding possible DNA?
No, sir.
Had you gotten any results in terms of the ballistics, the firearms, the trajectory, the stippling, whatever evidence regarding that?
No, sir.
Had you spoken to a girl or lady that was speaking to the victim on the phone at the time or right before the time that this murder happened?
No, sir.
Had you analyzed the phone records and the conversations between the victim, Trayvon Martin, and this lady that he was speaking to? Her name's Rachel Gentile.
No, sir.
Had you seen the 7-Eleven video?
No, sir, I had not.
You also did, obviously, reports in this case, correct?
Yes, sir.
And in some of those reports, did you in some way write down some inconsistencies, what you felt were some inconsistencies based on the statements that the defendant had given you?
Concerns of mine about his statements, correct? Yes, sir.
Okay. You mentioned at some point or you were asked about the size of the individuals, correct? Mr. Martin and the defendant, correct?
The physical sizes?
Yeah, I'm sorry, the victim.
Yes.
And I think, did you describe, I apologize if I got it wrong, did you describe the victim as a skinny kid or something to that effect?
Yes, sir, I did.
Would you classify the defendant, when you came into contact, as a skinny kid?
Would I classify the defendant as
Yeah,
skinny?
as a skinny kid?
No, sir.
Would it be fair to say the bottom line, sir, is that after February 29th and after a later date, the investigation was turned over to somebody else, is that correct?
As of what date, sir?
After that interview, at a later date in March, the investigation was turned over to another agency?
Yes, sir.
So, Mr. O'Mara asked you about phone calls that you had, telephone conversations with the defendant. Do you recall that?
Yes, sir.
Okay. Was your intent to eventually, if you could, attempt to interview the defendant again and challenge him, I guess to use Mr. O'Mara's words?
Absolutely, yes, sir.
If I could have a moment, Your Honor.
Yes, ma'am.
I don't have any further questions.
Thank you. And you recross?
Oh, yes, Your Honor. Let's now go through some of the areas that Mr. Delaroyanda talked about. Starting with, and again, I'm going to give a blanket apology for using some curse words, but when they exist in the case, they exist in the courtroom. So Mr. Delaroyanda was wondering whether or not you would use the term assholes in inviting somebody over for dinner. I think he said probably not. However, would you agree that if you were talking to somebody about something that you've used the words assholes probably thousands of times in your life?
I have used it.
Okay.
Yes.
And sometimes it's just used as just a slang term. Would you agree?
Yes, sir.
When Mr. Delarianda said those words to you, I think he said, assholes, didn't he?
In that tone,
Yeah.
approximately. Yeah.
Did you hear my client say that word, assholes, on the tape? We can play it again.
I heard him say it.
Okay. He didn't say it with the screeching voice that Mr. Delarianda did he?
No, sir.
He just sort of said assholes, right?
Yes, sir.
Did that, the way he said it, not the way Mr. Delarianda just said it, let's put that aside for a minute and speak more importantly about the way my client said the word assholes. Did that give you any cause for concern as to the way he said it?
No, sir.
Didn't show any ill will or hatred or spite when he said these assholes always get away? Did it?
If I may, not towards the individual. It seemed like more of a generalization.
Sure. Right. And of course, he was generalizing a little bit, correct? Because you know from your investigation that he was a bit frustrated that his neighborhood was being assailed by burglars, right?
That's how I
You
interpret
knew
it.
that.
Yes.
You knew that, as a matter of fact, you investigated and found out that a person, Emmanuel Burgess, was arrested 2 weeks before this event, a young black male, for having burglarized several homes in the neighborhood, right?
Yes, sir.
Late teens, tall, thin, just been arrested, right?
Yes, sir.
Sentenced to 5 years in prison for having burglarized a bunch of homes both in Retreat View Circle and outside, but still in your jurisdiction, right?
I wasn't involved in
That
that, but yes, sir.
But you found that out, and looking into everything that you were looking into to see what's going on in the neighborhood, you knew not only had Emmanuel Burgess been arrested 2 weeks before for burglarizing, but that there were a lot of other burglaries in that same neighborhood, right?
Yes, sir.
Were you concerned that he was concerned about that? Did that cause you any concern that somebody who involved themselves in protecting the community, being on neighborhood watch, would be concerned about a bunch of burglaries in the neighborhood?
Him being concerned, if I may, is one thing. As far as my personal feelings towards his actions the night of is a little bit different.
Sure, and we'll get to that in just a moment.
Okay.
But talking specifically to the issue of calling them these assholes always get away, were you concerned that he used the word assholes?
No, sir.
And you've used it yourself?
Yes, I have.
And not in a necessarily derogatory way, correct? Just as sort of a slang term?
It tends to be more towards derogatory, sir.
So ever for guys walk into the squad room, it's about dinner time, and go, okay, what are you assholes doing for dinner? Anything like that?
Personally, no.
Really?
Not that. I see what you're saying, but it could be viewed that way.
Okay. Just like when he used the word shit, right? Oh shit, he's running.
Yes, sir.
Any concern with that slang term?
No.
Don't suggest that that evidences any hatred or ill will on his behalf, do you?
As I interpret that was said with the infliction as a sense of urgency.
Yeah.
As if
Because-
something was happening bad.
Right, because he was just running away, correct?
Yes.
And then let's talk about fucking punks. Were you here for John Guy's opening? Did you hear it?
No, sir.
Oh. When Mr. Zimmerman said the words fucking punks, did he say it in a screeching, loud, aggressive voice the way Mr. Delarianda just recounted it to you?
No, sir.
Do you know why Mr. Delarianda yelled it at you?
To stress a point, to emphasize.
Right. But you heard it on tape, correct?
Yes, sir.
And how was it said on tape?
It's said as more as a matter of factly, as far as these assholes always get away. Or fucking punks. Yeah.
Right. Might show some frustration, correct?
Yes.
Okay. Frustration based upon the fact that other people in the neighborhood who have burglarized the place seem to get away on occasion, right?
Yes.
And in that sense, you said that there was no evidence that Trayvon Martin was doing anything wrong, correct?
None whatsoever.
You don't know that, though, correct?
No, I do not.
Right? You know that whatever he may have been planning to do just wasn't completed, correct?
I wouldn't know. I wouldn't know. There was no evidence to suggest that at all.
Matter of fact, there was a type of a tool found in the area where Trayvon Martin may have been hiding, wasn't there?
Approximately 5-6 days after the investigation at the scene, yes.
When you went back and you looked in the bushes and you found, what was it?
It was a piece of an awning belonging to, it was, I believe it was a piece of a window, piece of hardware, basically. It looked like a Slim Jim.
Slim Jim. And what's a Slim Jim?
Slim Jim's a device used to go ahead and jimmy locks on vehicles primarily.
To break into a vehicle.
Yes, sir.
And that was found a few days after this event.
Yes, sir.
Not particularly tied to this event by you, but it was there, wasn't it?
Yes, it was.
In the bushes just off of one of the residences, correct?
In the bushes behind Jonathan Manolo's residence.
So, would you suggest that the focus be on how Mr. Zimmerman stated the words fucking punks as opposed to the way Mr. Guy did in opening or Mr. Delarounda just did in your questioning?
I can't speak for Mr. Guys, but Mr. Delarounda, it was different.
Okay. Now, he also asked you that you were questioning Mr. Zimmerman on the fact that he was following Trayvon Martin, correct?
Yes, sir.
And Mr. Zimmerman said?
Words along.
You said yes, right? You said, wait a minute, were you following him? And in the interview, his word was yes, right?
In one of the interviews,
He
yes.
acknowledged to you that he was following him at one point, correct?
Yes, sir.
Anything wrong with following somebody like that? Let me ask you this way, anything illegal?
Objection, I've asked that he be allowed to
I'm sorry.
answer the question.
I'll let him answer that one.
Repeat it, please.
Anything, did you think that there was anything wrong with him following him to see where he was going?
Legally speaking, no.
Okay. Matter of fact, it was, and you heard the non-emergency call, right?
Yes, sir.
Okay. And it was twice on that the non-emergency operator asked Mrs. Zimmerman, tell me if he does anything else.
Yes, I believe that was said.
Right?
Yes.
Does that indicate that he wants him to keep an eye on him?
Yes, sir.
And you said following him is not legally improper, correct?
It's not illegal. No,
Even
sir.
approaching somebody is not legally improper, is it?
That's open for interpretation.
Tell me what crime you believe would occur if I were to walk up to you on the street and say, hi.
In that manner, none whatsoever.
How about, what are you doing here?
None whatsoever.
How about, get the hell out of here?
None whatsoever.
How about, I don't like the way you're dressed. I don't like the fact that you have gray on. Get out of my face.
That could be construed as confrontational.
Sure, but is that
Not illegal.
crime?
No, sir.
And when this operator who said twice, tell me if he does anything else, then says, are you following him? What does Mrs. Zimmerman say?
He says yes.
And in your investigation, is there anything at all to suggest at that time that Mr. Zimmerman continued to follow Mr. Martin?
At which point, sir?
At the point that the officer said, or the non-emergency operator said, we don't need you to do that, and Mrs. Zimmerman said, okay.
I would say yes, there was.
And what evidence would you have?
His end location.
Sorry?
His end location, the location where the incident ultimately ended.
Okay. So the fact that, may I approach the witness, Your Honor? For identification purposes, I'm going to the witness State Exhibit 139. Because you know the event started where?
the event, as far as I'm concerned, started off that matter.
Okay. I'm talking about the physical altercation. I apologize. My understanding from, well, what's your understanding as to when Mr. Zimmerman got to this area, what path he took?
You understand?
Please do.
Could you face forward?
Yes. Okay. My understanding of the interpretation is he's coming this way. He walks. So we got a pointer. Okay. He walks, per his statement, all the way over here. He says he doesn't see him. Okay. And the altercation, physical altercation, started right there, approximately.
Okay. Great. Thank you. So, with that as context, then, do you know exactly where Mr. Zimmerman was when the non-emergency operator said, we don't need you to do that?
Based on his statement, he was at his vehicle, which would have been, I believe, off of that or wherever he parked it.
Based on his statement, he was at his vehicle, which would have been, I believe.
Wherever he parked it on Twin Trees.
It's your understanding of the investigation that Mrs. Zimmerman was at his vehicle when the officer said, we don't need you to do that?
That was when he was exiting his vehicle. That's my
Okay.
understanding, yeah.
Okay, and then how many seconds went forward as he was walking before that conversation occurred?
Objection.
I'd have
Those
to,
facts, not in evidence, terms of walking.
Sustained.
How many seconds? You heard the tape where you can hear him getting out of the car, correct?
where I heard the sound of the door being opened, which I interpreted that.
That he got out of the car,
Yes.
right? And then you know that he was walking in some direction because he said to the officer in response to, "Are you following him?" He said, "Yes," right?
Objection is the facts not in evidence, walking, assuming a fact not in
Rephrase
evidence.
your question.
You know that he was following him because he told the non-emergency operator that he was, right?
Yes, sir.
And you know from the conversation that Mrs. Zimmerman indicated to the non-emergency operator that he had cut between the buildings, right?
Yes, sir.
Okay, so I might approach again, so just so we're clear with what you just testified to. He parked his car somewhere in this area, correct?
Correct.
And then, go ahead,
Back around here somewhere.
right?
So I'd have to hear it again, obviously.
Could
but
you face forward?
yeah, I'd have to hear it again, obviously. But somewhere very shortly thereafter, leaving his car, that's when it was asked, "Are you following him?"
Okay.
And he said yes.
And Mrs. Zimmerman indicated that Mr. Martin had gone between the buildings. He was out of sight, correct?
Yes.
Yet, you testified a moment ago that pursuant to Mr. Zimmerman's statement, he had gone down to Retreat View Circle, correct?
Well, that was his statement, but as far as him having a visual on when he might have got out of the vehicle, I really don't know. I can't say. It wasn't there. But he could have seen him at any point which way he was running. Am I making myself clear? I mean,
Well, the jury can decide that. I'll try and walk
Okay.
you through a little bit
Yeah.
more. So my question a little while ago was whether or not you had any evidence to support any contention that Mr. Zimmerman continued to follow Trayvon Martin after being told not to. Do you have any evidence to support that?
I would answer, I have information, yes, that there was, just based on where we located Trayvon and the fact that the altercation happened after his conversation. That's my interpretation.
Let
that,
me ask
yes,
it
there
this
was
way.
some
Let me ask it this
following.
way. Do you have anything to contradict Mrs. Zimmerman's statement that he walked the rest of the way to Retreat View Circle and was coming back towards his car when the interaction, whatever it was, between Trayvon Martin and him occurred?
Nothing tangible, no.
Go intangible on us then. So what do you mean nothing tangible? What do you have, if anything?
And the circumstances and the totality of the whole thing that I'm looking at, as I interpreted it, when he says follow, walking behind, trying to find a direction, I construe that as follow. He was trying to do something in the same direction where Trayvon was going.
He was
and
trying to see
as-
where he was.
As far as the word follow, as my report may indicate, I mean, it's, but it's open for interpretation.
And as your report indicates, there's nothing to suggest that Trayvon Martin went straight down Retreat View Circle, towards Retreat View Circle. He went between the buildings, correct?
According to statements made by Mr. Zimmerman. According to statements by your client, yeah.
And of course, all of those statements, including Mr. Zimmerman saying that he was attacked by Trayvon Martin coming from that area as well, correct?
Correct.
Anything to contradict that?
No, sir.
You understood from your conversation with Wendy Dorival, your knowledge of Neighborhood Watch, that if a crime is occurring, that you ought to call 911, correct?
I don't recall talking to Wendy Dorval about it, but I may have. But yes, that's what you do.
So if it's just a concern, like a suspicious person, you dial non-emergency, correct?
Yes, sir.
And if it's an actual crime occurring, you dial 911.
If those are the instructions, yes.
And which one did Mr. Zimmerman dial?
The non-emergency.
Evidencing, would you agree that he was not concerned that a crime was actually occurring, just that he was concerned about somebody being where they may not supposed to be?
Yes, sir.
And in your experience and knowledge, did you think it was inappropriate for Mr. Zimmerman to call non-emergency when he saw Trayvon Martin hanging out between two homes in the rain, in the dark?
Objection as to calls for speculation on his part as to whether it's
Sustained.
Your Honor, I asked you for
Rephrase
his,
your
okay. In your opinion, I don't want you to speculate as to what, but in your opinion, was that an appropriate, from law enforcement experience, was that an appropriate occurrence for him to contact non-emergency based upon seeing somebody who he didn't know at night in the rain between two homes, not walking away, just standing there?
My objection is to assume that those facts are accurate and truthful.
The jury,
Okay, you can answer the question.
That would be reasonable to
Reasonable,
call
correct?
non-emergency.
matter of
Yes.
fact, if you were driving an unmarked car past that at that precise moment and saw Trayvon Martin there, standing between two buildings at night in the rain, not moving, maybe even looking into a window, would you have stopped and talked to him?
Not just based on his presence. No, I would not.
And why not?
He might live there.
But the question is, would you stop and ask him?
Not just based on what you observed, no.
You agree that police, at least, are supposed to look into situations that might be suspicious?
If brought to the attention by a citizen, yes.
I'm sorry?
If brought to the attention by a citizen, such as
Oh.
George Zimmerman, yes, we are obligated to.
So you wouldn't do it on your own?
If on routine patrol, I can't say. Maybe.
Mr. Dolorionda asked you that if you had found out whether or not Trayvon Martin was armed, correct?
Yes, sir.
Do you also realize from the investigation, presuming for a moment that Mrs. Zimmerman's story is completely accurate and that he did in fact receive the injuries to the back of his head at Trayvon Martin's hands, that Trayvon Martin was smashing his head, hitting his head against concrete, correct?
Yes, sir.
Do you consider that to have armed himself with the concrete?
Yes, sir.
So, though he may not have been armed when he was walking, he certainly armed himself with something that could cause great bodily injury or death by hitting the head against concrete, correct?
Yes, sir.
And in the challenge interview, and know we go back and forth as to whether or not it was an interview with challenge, an interview for information, but again, for these purposes, calling it a challenge interview. Mrs. Zimmerman stated to you that his concern was that there were people who are out there, quote, victimizing the neighborhood, right?
Yes, that's what he said, yes.
And do you believe that his basis for that thought or even that feeling was well-founded? Let me ask it this way. How many burglaries had occurred in that neighborhood in the past 4 or 5 months?
I don't have those exact numbers, sir.
Would you consider it to be a rash of burglaries?
It would depend how many we're talking about. I don't know.
Well, limiting to the extent of what you looked into. I know you looked into Emmanuel Burgess, and he was arrested a couple of weeks before. And
Yes,
there were
sir.
other burglaries that you were aware of, correct, within the last few months before this event?
I'd have to refresh my memory as far as the number, as to consider it a rash of burglaries. To consider it a rash of burglaries or a crime spree, but I guess in his mind, yes.
And of course, burglaries are what occur when the people are not at home, correct?
Repeat, please.
A burglary that we're talking about now are those where the people are not at home when the crime occurs, correct?
Correct.
It's called burglary of an occupied dwelling or a home invasion when somebody's home, correct?
Yes, sir.
And that happened here as well, didn't it?
Yes, sir.
A woman, and you were aware in your investigation that a woman and her, I think, 4-month-old child had to hide in a bedroom closet while 2 guys downstairs took out her TV, laptop, and other items.
Yes, sir.
And that was only weeks before February 26th of 2012, correct?
Yes, sir.
And it may have been months before, a couple of months before, if I said weeks.
It had occurred, though.
Concerning the videotaping, and I can put you back to the tape, my memory, and tell me if I'm wrong, was that when you were bluffing Mr. Zimmerman about the idea that Trayvon Martin may have had a phone, that was videotaping things. You certainly did it in as believable a way as you could, remember?
Yes, sir.
You know how to get it across to him, correct?
Yes,
Did he
sir.
seem smug, as though he already had made this decision? Well, you can try and bluff me if you want, but I know he didn't have his phone out. Was there any of that came across to you?
No, sir.
In this challenge interview, was that exactly what you were looking for to see?
Partially, yes.
And none of that came across to you, did it?
None at all. No.
Matter of fact, he seemed quite interested in the fact that there may have been a videotape, correct?
Yes, he did.
Didn't he also say that maybe without his knowing, he'd hoped that the homeowners association had put up another video camera somewhere in that back area?
Yes, he did.
So he actually said to you, not only do I hope that Trayvon Martin was somehow taping this, or since he had the phone out or whatever, that somehow maybe it was on video. And he said, what was his words? Thank God, I hope he was videotaping it.
Words to those effect, yes.
He even said to you, well, maybe it's being videotaped from somewhere else. That maybe homeowners association had put up a camera going right down that dog walk that I wasn't aware of, or for that matter, any one of the dozen neighbors may have had a video camera out, correct?
Yes, sir.
Didn't he also indicate that he even hoped that maybe the one person who had come out, who we now know to be John Good, that maybe he had videotaped it?
I don't know if he verbalized that, but he seemed to be very open to having something videoed. Yes. He seemed to be very elated in the prospect that there was some sort of videotape.
Hoping that that would actually document what happened that night.
Yes, sir.
Another challenge that you did, just a moment for my own, another challenge. At least I didn't do a complete pirouette. And I said, excuse me first. Thank you. Another challenge that you did to Mr. Zimmerman was concerning this question about the hands over the face, correct? Because
Yes,
that
sir.
was a concern of yours, right?
Yes, sir.
Because he had said he placed his hand over my face at one point. I really thought he was suffocating me. Words like that, correct?
Yes, sir.
And yet, on the screaming of the 911, there wasn't a great deal of muffling. Would you agree?
No, sir, there was not, yes.
And had there been muffling, then it would have even been perfectly coordinated with what Mrs. Zimmerman told you, because then the suffocating, muffling would have shown up on the tape. But in this case, it didn't, correct?
Correct.
You would agree that the screams are from one person, correct?
Based on how I interpreted, yes.
Okay.
Yeah.
And that they were just that, screams, stop, scream, stop, correct?
Yes, sir.
Okay. And I think you said that you also believed Mr. Zimmerman may have exaggerated as to the number of times getting hit, correct?
Yes, sir.
Mr. Delarosa brought that up again as an exaggeration, right?
Possible, yes.
Yeah, I think we talked about it as to how it might be perceived when you're the one getting hit, correct?
Yes, sir.
Okay. May also be that you perceive getting smothered even when somebody has your hand on their broken nose.
Possibly, yes.
Okay. May have actually had a hand on his mouth or nose, but just not enough to interfere with Mr. Zimmerman's continued screams for help, correct?
Correct.
So even though you challenged him on that to try and come up with an answer, and he told you, I don't know, right?
Correct.
Did he change his story at that point, realizing that now you got him on a fact, and just say, well, actually I turned over and I was screaming the other way, and that's what? Did he do any of that?
No, sir, he did not.
He just basically said, I think he had his hands on my head, right?
Yes, sir.
I think he was trying to stop me from
Yes, sir.
breathing. And it hurt.
Yes, sir.
And just so we're clear in that regard, would you agree that there may have been some screams muffled enough so that they simply didn't show up on the tape?
There could have been, possibly.
With that last challenge, call it the suffocation challenge, was there anything in that challenge of Mrs. Zimmerman that you thought then was problematic? The way he answered it?
No, sir.
Now let's talk about the video where Mr. Zimmerman seems, maybe for the second time, to not notice Miss Lauer's number on the right-hand side, correct?
Yes, sir.
And as he's walking you through it, again, voluntarily doing what you wanted him to do, right?
Yes, sir.
He sort of looked over and he said, I didn't see anything here, correct?
Yes, sir.
And obviously, had he looked to his right, if he had been in that correct spot, and had he not been blocked by the tree that the jury has seen from another picture, then he might have seen, or could have seen, Miss Lauer's numbers, correct?
Yes, sir.
Would he have seen them if he had just started walking by and just got past Miss Lauer's, the front door right there? Is there any number on the side of that building?
No, sir.
Okay. So if I might carefully approach Your Honor again. Just so we're clear on, again, States 139. This is Miss Lauer's, and front door here. Number is sort of on this side.
Yes, sir.
So
Facing the street.
Right, facing out this way.
Yes, sir.
So if Mr. Zimmerman had gotten to this point or was looking around, doing whatever he was doing, as soon as he got to somewhere in this point, he would not have a line of sight to
I'm
those.
going to object to misstating what Mr. Zimmerman said on video as to where he was when he didn't or did see the address.
Okay.
I'll clear that up.
Rephrase your question.
No one could see the numbers once you get past this, correct?
Correct.
And you do agree that Mrs. Zimmerman was trying to do the best he could to acknowledge what he was doing in the recreation, correct?
By appearances, yes.
He seemed to be doing everything that he could to explain to you what he was doing?
Yes, sir.
As he was doing this, was it a situation where you just sort of letting him run with it, or were you asking him any questions along the way?
I believe some questions were asked for
Yeah.
clarification.
Sure. And when he said, as he's walking with Miss Lowers to the right of him, and he's sort of looking this way, the car is somewhere near where he said he parked his, right?
From what I recall, yes.
And you had the non-emergency call already known by the time you did the recreation. So you knew an idea of the series of events, correct?
Yes, sir.
You knew that he had said that I'd gotten out of the car about here, right?
Yes, sir.
And that he was walking down that road or doing something, walking, running, jogging, whatever he was doing. He was ambulating down that pathway, correct?
Yes, sir.
That he sort of looked over and said, I couldn't see any numbers. And he looked to his left, correct?
From what I recall, yes.
Yeah, did anyone ever think at that point to go, excuse me, if you back up and look over this way, there's a number. Why didn't you look at that number?
If it wasn't mentioned, no. We were,
Did you ever do that afterwards?
no.
Did that seem, in the context of what he was trying to explain that happened to him that night, that ended up with what it ended up with, that that was some type of active deception to you?
I didn't interpret it as such, no.
Okay. I mean, it doesn't make a lot of sense in your mind that he couldn't remember the name of the street, correct?
Correct.
Like you said, there's only 3 there, correct?
Correct.
Did you, and you even questioned him about that, right?
Yes, sir.
But did that show to you to be some active deception on his part?
The fact that he couldn't remember the 3 streets could have possibly, yes, it did raise flags and concerns.
Okay. And did that lead to any concern? I mean, you addressed it in this confrontation interview, correct?
Yes, sir.
And you okay with what he responded?
That's all I could do is be okay with it. And that's
Okay. And then you were questioned about a number of things concerning the investigation. So I want to talk to you about some of those.
okay.
The medical examiner's report. You had a chance to review that, correct?
Yes, I have.
Okay. And the medical examiner's report and its findings were consistent with Mrs. Zimmerman's story, were they not?
Yes, sir.
Okay. As far as how he shot him, correct? Where he shot him?
Yes, sir.
And the distance between the muzzle of the gun and the clothing, correct?
Yes, sir.
And also that there was a gap of a few inches between the clothing and Mr. Martin's chest, correct?
Yes, sir.
Evidencing that though the muzzle of the gun was up against the chest, up against the shirt, that the shirt was not up against the chest, that there was a few inch difference,
Yes, sir.
right? And didn't that support the contention that Mr. Martin was hanging over Mr. Zimmerman, his shirt coming forward when the shot was fired,
It did.
right?
Yes.
Because had he been standing up, as I am now, the shirt would be up against the chest, probably, right?
Probably, yes,
And
sir.
if I lean over, my shirt is going to fall apart from my chest a few inches, and that seems to be how it was, correct?
Yes, sir.
The medical examiner's report, however, does not support a contention, an allegation, that Mr. Zimmerman pressed that gun against Trayvon Martin's chest before he fired it, does it?
Not from the one I
Matter
read.
of fact, the known evidence completely contradicts that type of a suggestion, doesn't it?
From what I understand, yes.
So no pressing of the gun against the chest, was there?
Not based on evidence that I've read, no.
And You saw the 7-Eleven video since, right? Though I think Mr. Delaronda suggested you didn't have it then. You've certainly seen it since.
I don't think I viewed the video itself. I think that was bought after I was.
No, but have you seen it?
I've seen stills,
Okay.
still photos.
And the stills that you saw showed Trayvon Martin in it
Yes, sir.
and show him the way he appeared that night?
Yes, sir.
So when you say that certainly in the autopsy photograph that you wanted to show Mr. Zimmerman, which again was part of the challenge interview, correct?
Yes, sir.
You hit him with something sort of emotional and to ground him that he had caused the death of this person?
It was graphic. Yes, sir.
And that's the purpose of it, right?
Yes, sir.
Okay. But the picture of Mr. Martin at 7-Eleven, would you agree that that shows somebody at his height, whatever that might have been, in the shoes and the hoodie, and wearing the outfit that he was wearing, that he did not look in the 7-Eleven video to be the skinny kid that you showed the picture of to Mrs. Zimmerman, correct?
Correct.
Much larger looking individual?
I would agree with you. Yes.
Okay. My height or so? I'm
Correct.
6'2", right?
Yes.
If I was wearing a hoodie and had his shoes on, correct?
Yes.
So when you talk about relative size, although I think you said that Mrs. Zimmerman, not today, but back then, wouldn't come across as a skinny kid, correct?
Correct.
When you look at the actual height differential, there was quite a height differential, wasn't there?
Yes, there was.
And therefore a reach differential?
Yes, sir.
You know what that means, right?
Yes, I do.
What is that?
The reach is measured arm to arm, sideways.
If I might have a moment, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Let's start at the very end. Would you agree that after somebody dies, they don't get taller?
Excuse me. I'm sorry.
Have you ever heard of when people die that they get taller?
Oh, no, sir.
So you're not disputing if the medical examiner were to say they measured him on a table that Trayvon Martin was only 5'11". You're not disputing that, are you?
No, sir.
I mean, you're not trying to tell the jury that after Trayvon Martin died, he grew to be 6'2".
No,
Are
sir.
you?
No.
I mean, have you ever heard of that? Somebody dying and growing taller?
No, sir.
Okay. And by the way, Mr. O'Mara asked you, I want to make sure I understood your answer. Are you saying that in Seminole County, it's against the law for somebody to wear a hoodie at night?
Objection, Your Honor. That is a mischaracterization of the evidence in my question.
Okay, I think you need to rephrase it because you started.
Are you saying that it's against the law for a person to wear a hoodie at night?
No, sir. No, sir. I'm not.
I believe in your investigation and your interview with the defendant that he had a phone, correct, that night?
The
When
defendant?
when he observed the victim, Trayvon Martin? The defendant had a cell phone,
Yes, he
right?
did. Yes.
You didn't find any evidence that the defendant, when he's claiming he's seen the suspicious activity, videotaped or photographed the suspicious activity that he claims the victim was doing.
Let me object, Your
Was there
Honor.
any evidence of that?
Just a second, what's the objection?
Outside the scope of recross, unless we're opening up that new area.
No, overruled, it's not opening it up.
You were asked about videos, right? Was there any evidence to indicate that when the defendant claimed that the victim was committing a crime or was about to commit a crime, that he videotaped it since he had a phone with the ability to videotape or take photographs? Did he ever do that?
No, sir.
You were asked about this item that was found behind some bushes. Isn't it true that was part of an awning that Mr. Manalo had there?
It was part of his house, yeah.
Right? There was
Awning.
no
Yes,
evidence to
sir.
indicate that was used as a tool or a Slim Jim or anything like that.
None whatsoever.
And you would agree that an expert, or if he's qualified as an expert, a medical examiner or assistant medical examiner would be better qualified as to the findings that he made versus you saying what he said?
Yes, sir.
You would defer to a medical examiner, would you not?
Absolutely.
Mr. Romero asked you some questions about the burglaries that were being committed out there at Retreat Twin Lakes that you investigated or determined there was some, right?
Yes, sir.
And that the defendant had made calls about them, right?
Yes, sir.
Okay. And I think Mr. Romero referred to it as a black male, right? At least one of them he referred to. Did you know whether the other individuals he had called on were black males or not?
From what I recall researching, yes. From what I recall researching then, yes, they were.
Mr. Romero asked you a bunch of questions about the word, pardon my language, asshole. And did I understand you correctly to say that that is a derogatory term in describing somebody or referring to somebody?
In my opinion, yes.
And Mr. Romero asked you about the words that the defendant uttered on February 26th at around 7:10 before he followed the victim. Do you recall him specifically under his breath saying, pardon my language, these fucking punks? Do you recall that's the way he uttered it?
Yes, sir.
Okay. Now, you read any comics?
Never what?
Do you read any comics?
Comics.
Comics? No?
No, I
You know how they
don't.
have a little caption where they have like a little bubble because they kind of what the person's thinking?
Yes, sir.
Okay. At the time he got out of the car and was getting out of the car, defendant said the words, these fucking punks, pardon my language, right?
Yes, sir.
And then he followed Trayvon Martin, correct?
Yes, sir.
Mr. Romero asked you a few questions about suffocating. Do you recall being asked questions about that, suffocating?
Yes, sir.
Now, the defendant claims that the victim was suffocating him, correct?
Yes, sir.
Okay. Did you find any evidence of blood on the victim's hands?
None that I'm aware of. No, sir.
And there was evidence that the defendant was bleeding, especially on his mouth, right here on his mustache. He had some, right under his nose, he had some blood, correct?
Yes, sir.
May I approach the witness, Your Honor? I'm not going to hit you, but
You can hit me. That's
if I can. And I'm hitting you, correct? That's what the defendant's claiming, that I'm suffocating you and I'm not going to put my hand in your mouth.
That's fine.
Would you have your hands like that, just like this? Or would you be fighting me?
I'd be fighting you. I would fighting you. Make sure you got that.
Did you find any blood or anything on the defendant's hands?
No, sir.
You were also asked about witnesses and stuff. And if I may approach the witness again. State's Exhibit 140, Mr. Romero showed you this. You recall this? And he asked you in terms of assuming that, and I apologize, he may have actually shown you 139. I apologize. Let me take both up so that. 139, he asked you about assuming the defendant's story is correct in terms of where the altercation had, et cetera.
Yes, sir.
Did you have some evidence that possibly there was something going on behind these houses here, the Bahador's house?
Yes, sir.
You were asked asked about the hoodie at the 7-Eleven. I'm not aware of, but what law states that an individual can't go into a 7-Eleven with a hoodie? Is there some law that I missed?
No, sir.
I have no. And finally, you did not have the phone records in terms of Trayvon Martin or Rachel Gentels, right, the lady you did not know he was talking to determine whether it was accurate based on when the defendant's phone finished or not.
No, sir, I did
In
not.
other words, you didn't have the defendant's phone records either, did you?
No, sir.
And I'm talking about in the February 29th interview. I apologize.
I was assuming that, yes.
Thank you. No further questions.
Thank you. You know, we've been here almost 2 hours this morning on cross, redirect, recross, redirect, and now you're seeking to recross. I will give you 5 minutes. It's the state's witness, and the state will then have another 5 minutes on redirect.
Sorry, Your Honor, there's just new areas gone into it, I have to address them.
Well, you have 5 minutes
I will take it.
for your
Hopefully less.
recross.
Yes, Your Honor. Now, as far as any blood on Mr. Zimmerman's hands, of course, when he got to you, he was already cleaned up by EMTs and he had washed himself at SPD, correct?
Yes, sir.
You wouldn't expect to find blood on his hands at that point, would you?
No, sir.
And when the suggestion is, why didn't Trayvon Martin have blood on his hands, is blood susceptible to gravity as well? Like
Yes,
most
sir,
other
it is.
things? So if he gets smashed in the nose and is thrown on the ground, which way is the blood going?
Towards the ground and
And back down his throat?
back down his throat or...
Right? And only when he stands up is it going to start coming out of his nostrils?
Yes, sir.
Which is after he's no longer being mounted by Trayvon Martin?
Typically, yes, sir.
Okay, so break my nose, put me on the ground, my blood's going backwards into my throat, right?
Theoretically, yes.
And would not be available to be on Trayvon Martin's hands at that point because there was no blood outside the nose, correct?
Correct.
And I'm not going to approach you like he did, but basically, first of all, let's use the left. If he's holding him down, could that be literally momentary that he's holding him down and that Mrs. Zimmerman is trying to get back up?
Yes, sir.
And could the attempt to suffocate literally be momentary as well?
Yes, sir.
Could it even be a sleeve or an arm or a palm or anything that could have given Mr. Zimmerman that impression?
Yes, sir.
Thank you, Your Honor.
Thank you. You have,
I think I'm only going to ask 2 or 3 questions.
thank you.
I may only ask one. Right now, it could be raining outside, right?
Yes, sir.
And that would be pure speculation on your part, would it not?
Yes, it would.
Thank you.
Okay, thank you. Officer Serino, you're excused from the courtroom, but you're subject to being recalled. Thank you very much. Ladies and gentlemen, I think we'll take a 15-minute recess. If you'll please put your notepads face down on the chairs and follow the deputy back into the jury room.
As they walked out, you didn't release him from
Please be seated, and I did tell him it was subject to being recalled. Is there anything we need to take up before we recess for 15 minutes?
No, Your Honor. No, Your Honor, thank you.
I have a motion on filing at this point, Your Honor. It certainly doesn't need to be addressed right this minute.
Okay.
But it's in response to a motion the state filed yesterday. I don't know if they've noticed it for hearing or not.
I haven't received any notices for hearing, but we'll go ahead and take your motion.
Thank you.
We'll be in recess. Please be seated. Court is in session. Are we ready for bring the jury in and your next witness?
Yes, Your Honor. Will you call Mark Osterman?
Well, we'd have to get the jury in first. That's okay. Let's go ahead and bring the jury in. Oh. Trish.
Jury's present, Your Honor.
Please be seated. And please call your next witness.
Today we call Mark Osterman.
Raise your right hand, please. Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
You may. Yes, you may.
You state your name for the record, please, sir.
Mark Osterman,
And could you spell your last name?
Osterman.
And do you work for a federal agency, sir?
Yes, I do, the Federal Air Marshal Service,
Okay. How long have you been so employed?
since December of 2001.
Okay. Do you know a person by the name of George Zimmerman?
Very well.
Okay. And is he seated here in the courtroom today?
Yes, he is.
See, the person just stood up.
Yes, he is.
Your Honor, the record reflect the witness identified the defendant, George Zimmerman.
The record will so reflect.
And how long have you known him approximately?
At least 5 years.
Okay. And you knew him back in February of 2012, is that correct?
Yes, I did.
Okay. And would you consider him a very good friend?
Best friend I've ever had.
Okay. I want to draw your attention to February 26th, February 27th, the evening of February 26th, 27th. Did you get a call and you end up responding to the retreat at Twin Lakes?
I did.
And did you meet the defendant's wife, Shelley Zimmerman, there?
I did.
Okay. Later the following morning, early morning of the 27th, did you come into contact with the defendant, George Zimmerman?
Yes, I did.
Okay. And did you transport him somewhere with his wife, Shelley Zimmerman?
I did.
Okay. Did he make some statements to you regarding what he alleged happened regarding the shooting he was involved in?
Yes, he did.
Okay. And did he specifically state that that Sunday night, the 26th, he had was going shopping at Target?
I
Correct.
object, Your Honor, leading.
Okay. If you could, tell us what the defendant told you, and let me set the setting if I could. You were with yourself, and I believe you were driving, is that correct?
I drove myself.
Okay.
You
I
referring
apologize.
before?
I believe I got to rephrase the
Go
question. I
ahead.
apologize. Confused on my part. When Mr. Zimmerman, the defendant, was telling you something about what happened, he was in the car with you, is that correct?
That is correct.
And were you driving?
I was.
And was his wife, Shelley Zimmerman, in the car with you and him?
She was.
Okay. And did he make some statements regarding what had happened regarding the shooting?
He did.
Okay, if you could tell us what the defendant said regarding what he alleged happened.
George said that on that Sunday night, he had left his home, as he did every Sunday night, to get lunches for the week. And as he was going to go to Super Target, which is really, really close to his home, he was going to, he just drives out of his neighborhood, and I think it was dark that night. And on his way there is when he observed someone in a black hoodie and someone who was looking like someone he had not seen before. And he knew most of the people in his neighborhood. So he had observed someone walking through the neighborhood with a hoodie on, looking either into windows or looking into around residences and such.
All right, let me interrupt you if I could. Did he describe the individual he said?
He did.
How did he describe him?
Tall, about 6 foot, and about slender,
Okay.
slender build.
And he stated the person was doing something, you said?
He said walking through between two sets of townhomes, when you look to your left and right, you would look into windows. You wouldn't be in a position really to look into either the front door or such, but it was side windows.
Yes, sir. Did he further describe the individual by race or ethnicity?
Well, at that time, he knew that he was a black male.
Okay. I apologize. I interrupted you. You said, what else did the defendant tell you regarding what happened?
He said then when he realized that the person that was walking through the neighborhood was someone he didn't know, he didn't recognize, and someone who usually looks through a neighborhood while it's raining, it's suspicious because a lot of times juveniles will walk through neighborhoods or people who are suspicious will walk through neighborhoods while it's raining because you get less people walking around, walking their dogs, or just taking an evening walk. So someone who might want to be a little more suspicious, if they're acting suspicious, they'll do it when it's dark and when it's raining. And that might have been a trigger, he had said to me.
Right. Okay. What I want to do is focus as best you can in terms of what you recall him saying as opposed to...
I'm sorry.
No, that's all right.
Yeah, he said he observed what is now, we realize is Trayvon, walking between the two buildings. And then he came down and he observed him, thought it was suspicious, and that he was going to call the non-emergency number for the Sanford Police Department.
Did he state that the individual that we're referring now as Trayvon Martin starts toward him and came under the light, and so he was using his phone?
Correct. George was using his... I'm sorry, did you mention George was using his phone or Trayvon?
What did he say?
I was never told by George that Trayvon was using his phone.
I'm sorry, that
George was.
George, I apologize.
Correct.
George Zimmerman was using his phone.
Correct. He dialed the non-emergency number, and he wanted to make sure that he called that line instead of the 911 line.
Did he say the person you know now as the victim, Trayvon Martin, approached this car?
Walked close at this point.
Okay, what does he say about that, if you could?
Walked down to the street, about where, because George had remained in his vehicle, and Trayvon had walked down, I guess down to the sidewalk area, walked a little further away, walked back a bit, and then George had, I believe, pulled into the front of their clubhouse and parked his vehicle there and waited for Sanford Police to arrive and
Okay, does
make
he say,
contact.
I apologize, I interrupted you, sir.
No, I'm sorry, just...
Okay, did he say that the person you now know is Trayvon Martin? When I say he, I'm talking about the defendant, George Zimmerman.
Right.
That he walked up to the passenger side window and stood there for a moment, then goes to the front of the car, comes around to my window, my driver's side, then towards the rear of my car, then walks away?
Yeah, it was walked around at the vehicle, very in a close proximity, and I think they looked at each other, George had said.
Okay. Did he, the defendant, then say that at some point then he lost sight of the person you now know as Trayvon Martin?
Yes, briefly.
And do you recall then in terms of Mr. Zimmerman, the defendant, saying that he was talking to the dispatch or to the non-emergency person, correct?
Yes.
And did he tell you that in terms of whether he was asked, are you following him? And he answered, yes, I'm following him, but he didn't see Trayvon Martin at that time, was looking for him?
Well, there's kind of two, as George described it to me, there were kind of two phases of the contact. The first one was when he first saw him, and then he pulled into the clubhouse parking lot. And then the second one was when he reestablished contact with Trayvon, who walked down another side street that wasn't the main street around the circle. And then he backed his car up, and then he tried to keep a visual contact with him, so he followed him with his car. And he didn't get out of his vehicle until he lost visual sight of him.
And then do you recall the defendant telling you that the officer or the dispatcher, I use officer just because they're with the police department, saying to the defendant that we don't need you to follow him, and he said okay?
Correct. That was at the point where he had already gotten out of his car first. And as he described to me, was there were two reasons for getting out of the car. First, he didn't know the street. I guess he was on that center street. It's a smaller street. He didn't know the actual name of it, so he got out of his car to try to establish a visual contact to try to direct the police officer in to meet with Trayvon and dispel his suspicions, and to find the exact address. Because as a police officer, you always want to know the exact address of where you're going.
All right, and then he told you, I'm sorry, the defendant, I apologize for using pronoun, that he started walking and then he put his phone somewhere?
He put his phone in his pocket after the dispatcher told him they didn't need him to follow him, so he was going to walk back to his vehicle.
Okay, and then he said something happened at that point?
He told me that as he was walking back to his car down the dog path, that Trayvon had confronted him, had walked towards him and confronted him, and they had a verbal.
Okay, and what do you recall a defendant telling you that Trayvon Martin told him, and what did he say in response?
He cursed. I'm not going to curse here today. He said, do you have a problem? And then he used a curse word.
All right, now, you wrote a book about this, right?
I did.
And you wrote a book and where you quoted what the defendant, George Zimmerman, told you, correct?
Correct.
And do you recall in that book writing, do you have a problem, that's what he said Trayvon Martin said?
Right. Correct.
Okay. And you didn't put in that book anything about a curse word at all?
I believe I did.
You did? Okay.
I believe I did. Do you have a problem? And then he used the initials MF.
Okay. May I approach the witness, Your Honor?
Yes, I may.
I'm going to show you your own book. And unless I've got the wrong page, I'm on page 28, counsel. Just to refresh your memory.
Correct. Correct.
And don't read from it, you just, this
Okay.
is to refresh your memory.
All right. Yeah, he had told me that, do you have a problem? And then the curse word, it was taken out of the book because it was pretty graphic. And I didn't wanna-
Okay, so you on purpose you took it out?
I think the publisher had
Okay.
asked that not be put in.
Because you put on there, do you have a problem? And then Mr. Zimmerman, that you said, replied, no, I don't have a problem.
Correct. And it was
But
correct.
you believe the words were actually what now, the defendant said?
MF.
Okay, so these juries have heard, so just for the record to be
Okay,
clear.
I just
He
don't-
said, do you have a problem, motherfucker?
Correct.
Okay. And then the defendant, Mr. Zimmerman, said in reply, no, I don't have a problem. And then Mr. Trayvon Martin replied?
You do now.
Okay. And the defendant claimed that Trayvon Martin, was coming at him at that time?
He was very close, probably within an arm's or 2 arms reach.
Okay.
And George lost contact
And-
visually.
And I apologize.
Okay.
I
I'm sorry. Go right
interrupted
ahead.
you.
Go right ahead. No, he, as George was reaching down to get to his phone to reestablish contact with the dispatch, that's when physical contact happened.
So the defendant told you that he has these words with Trayvon Martin,
Correct.
and then he said that he went and reached for his phone in his pocket.
Correct. I looked
And so-
down.
I'm sorry, he looked down.
He looked down to reach to get into his pocket,
And at that point is when Trayvon Martin hits him?
struck him in the nose.
Okay. So the defendant claims he looked down, and that's when Trayvon Martin hit him.
Well, he looked down, got his phone, and he said as he looked back up, he lost visual contact for maybe a second. To get his phone out of his pocket, he went like this, and as he looked up, the punch came squarely in his face.
So did the defendant say he took the phone out or left it in his pocket?
I don't remember that.
Okay.
I don't remember.
And then what did the defendant claim after he claims the victim hit him in the nose?
He stumbled backwards and found himself on his back,
Okay.
partially on the grass, partially on the sidewalk.
Did he say what the victim, Trayvon Martin, was doing at that point?
He moved forward and got on top of him.
Did he describe to you how he got on top of him?
His knees were up somewhere near his chest or up near his armpits,
Okay.
and he was beginning to punch him.
Okay, so the defendant is claiming that the victim straddled him, I guess?
Correct.
and his knees were up and his ribs and near his armpits, correct?
Correct.
And he began punching him.
That's what George said.
And I apologize, he began punching Trayvon Martin. Okay.
Trayvon began punching George Zimmerman.
I'm sorry, then I got it backwards, sorry. The defendant's claiming he's on the ground,
And
Trayvon Martin is straddling him.
Was punching him,
And-
George. I'm sorry.
I apologize, Mr. Officer.
I'm sorry. He said that he was on his back, and Trayvon Martin straddled him and began punching him in the face.
But the way he described Trayvon Martin straddling the defendant, he claims that you said his knees were up to his rib cage or armpits, is that correct?
Somewhere around there, correct.
Yes, sir. Then he said, what?
Well, George began screaming for help at that point.
Did he say anything about the defendant grabbing his head and doing something with his head?
Absolutely. Once he started screaming, George said Trayvon grabbed his head and started bashing his head on the concrete, which his upper half of his body was on the dog path.
Right. In fact, I think you quoted Mr. Zimmerman, the defendant, saying that he was 8 inches from the grass, correct?
About, as George was explaining it, this upper half of him, somewhere of this where it was still on the concrete, where the rest of his body was on the grass.
And I think your quote is, I noticed that I'm about 8 inches away from the grass, correct?
Correct.
And then does Mr. Zimmerman, defendant, tell you that I tried to maneuver the body just enough to get my head onto the grass?
It was a squirm, he said. He said as he was squirming down towards the grass to keep his head from getting hit by the concrete, he says his jacket kind of remained still as you squirm. His jacket, since it wasn't buttoned, it stayed where it was, and his body moved towards the grass a little bit more.
What else did he say about anybody seeing this or coming out?
He said there were several people that came out, at least 2 that he saw that came out, and he directly screamed for help towards those people. So as he was screaming, it was more directed at someone.
And did he say one of the individuals that came out was a man, and he yelled directly at him, and the man just went right back in?
He stated he was going to call 911 and he wasn't going to get involved.
And did he say then there was other individuals that saw this too, correct?
Perhaps at least one other, for sure, that witnessed what was happening. It may have been the same person that had the flashlight that showed up later.
I think you can refer, if you need to refresh your memory, on page 28 where you quoted Mr. Zimmerman. Did you not, at the very bottom of page 28 of your book?
There were several people.
I think you said 2 other men saw us out there and did nothing.
Correct.
Correct?
I believe so. At least one other, maybe 2 others.
And then he claimed that Mr. Martin, or Trayvon Martin, was still on top of him and took his hands and put it over his nose, correct?
One hand was trying to cover his nose, one hand was trying to cover his mouth to keep him from screaming.
Right. And I think you quoted Mr. Zimmerman as saying that Trayvon Martin put his hand, takes one of his hands and puts it over my nose and pinches it closed while his other hand goes over my mouth.
It was described to me something like this, maybe a pinch, maybe not like that, but a pinch like that and a cover.
So, in other words, Trayvon Martin is using one hand over his nose and then one hand over his mouth, correct?
It's something to that effect.
And then, what does Mr. Zimmerman, the defendant, say happened then?
He said that because his jacket rode up a bit, that perhaps with the inside of his leg, he felt or looked down and saw that he had a holster and a firearm.
Okay. Before the defendant said that, did he say that he desperately got both of my hands around the guy's one wrist and took his hand off my mouth long enough for me to shout again for help?
Right. That was the main thing he did with his hands, was to try to clear his mouth. Because with his mouth free, he could scream and he could breathe.
Okay. So the defendant is describing to you that Trayvon Martin's got one hand pinching or going with his nose, and then he's got the other hand over his mouth, right?
Trying
he can't breathe or
Correct.
Have I got that right?
Correct.
And then the defendant is claiming that he took his hands and removed at least one hand off of Trayvon Martin.
Off of his own mouth.
Okay. Defendant's claiming that he never hit Trayvon Martin at that time, or never just knocked him off of him, right?
That was not described to me.
Okay. And then the defendant told you he had a brief control of the wrist, but then he said, I knew when he felt the sidearm at my wrist with his leg, correct?
Say that one more time, sir?
For a brief moment, I had control of the wrist, but I knew when he felt the sidearm at my wrist with his leg.
That's when he let go of the other hand let go, and he said that he went for the gun.
Okay. Did he
Grabbed
say
for it.
Trayvon Martin went for the gun, correct?
Grabbed for the gun.
Okay. And I think you quoted him as saying he took his hand that was covering my nose and went for the gun, saying something at that point, correct?
He did.
He said, what words did he utter?
He says, "You're gonna die," and he used the MF term again. I'm sorry, I don't like to curse in front of ladies.
And for the record, he used the word, you're going to die now, motherfucker, correct?
That is correct.
And then I think you got the defendant quoted as saying, somehow I broke his grip on the gun when the guy grabbed it between the rear sight and the hammer, correct?
Could have been the leather, could have been the gun.
Well, I think you quoted him on page 29, and refresh your memory if you need to,
Correct.
as, under quotations, somehow I broke his grip on the gun when the guy grabbed it between the rear sight and the hammer. So
That's where the leather strap is, though. That's what holds the gun in.
So the defendant is claiming that the victim actually grabbed the gun,
That was my understanding, that he grabbed the gun. That would have been the only place that was available to grab.
And then he said the defendant, managed to get the gun in his hand and raised it towards Trayvon Martin's chest and pulled the trigger, correct?
Unfortunately, yes.
And then he claims after he shot Trayvon Martin, that Trayvon Martin sat up and he heard him say, you got it, okay, you got it, something like that.
Correct.
And then that Trayvon Martin pivoted 90 degrees and fell face forward onto the grass, and he scooted from under him.
Correct.
And the defendant claims he didn't know he shot him.
He didn't know he struck him, correct.
I'm sorry, struck him.
Correct.
In fact, the defendant went on to tell you that he thought Trayvon Martin, I know he wasn't calling him Trayvon Martin.
I understand.
I think he referred to him as the guy or whatever. Might try to get up again, so after putting his gun back in the holster, he jumped on top of Trayvon Martin and pinned him down, correct?
Correct.
And then he said a man approached him out of the darkness and
First
thought it
man
the
was
police,
not.
correct?
First man was not a police officer. The second was.
And you recall also that when he's describing in terms of the first contact he had out there when he was calling the non-emergency number, that he said, we need you to get to a place where you can see him in terms of observing Trayvon Martin?
Right. Well, he had said that he had to get somewhere where he could observe Trayvon or observe any subject that's in his neighborhood to be able to direct police officers to them. So whether he actually, whether the dispatch actually said, we need you to move to where you can see them, I'm not sure if that actually was what occurred. But he had said that his instructions from Sanford Police, whenever they came to their complex, was always to get to where you can observe and try not to make contact.
And he told you that the officer was almost there at the scene in about 45 seconds or something, or the dispatcher's telling him that, correct?
Well, I guess Time is relative at that point, but yes, very, very shortly after.
I'm saying, when he's talking, he's saying that the dispatcher's telling him the officer's almost there. He's
Correct.
within 45 seconds.
Correct.
And he told you that, and I'm going back now in terms of when the dispatcher, he tells you that he told the dispatcher to just have the officer meet me at the clubhouse, correct?
That is correct.
And that he put his phone in his pocket to turn around to head back to the car when the guy is there about 15 feet away from walking towards him, right?
Correct.
So he's saying that Trayvon Martin, I apologize, I'm using the name Trayvon Martin, but you know who I'm talking about.
Correct.
He's describing this person is 15 feet away and walking towards him, correct?
Correct.
And he says, do you have a problem? And then what occurs? You said he said some other words, MF, but you didn't put it in the book, correct?
Correct.
He also told you that when he managed to get his hand off of Trayvon Martin's hands off his mouth, that he had control of the wrist, correct?
To some degree, to prevent him from putting it back over his mouth, yes.
Right. And he told you that the defendant, managed to break the grip on the gun where the guy grabbed it between the rear side and the hammer, correct?
Whether it was the gun or the leather casing or just reaching down there and grabbing something.
Right, but I
He
think,
broke the grip of the gun or the holster.
now, you didn't refer to the holster when you wrote it down in the book, correct? You just put gun.
Correct.
Right.
Because the holsters, that's exactly the place where the holster holds the firearm in place. So whether it was actual firearm or holster, I didn't see a difference. If someone grabs a hold of the holster or grabs a hold of the gun, their intent is probably the same.
And the defendant's telling you then that he shot at Trayvon Martin, but he didn't know whether he struck him or not. He
Correct.
thought the shot went wide, correct?
He did say that.
Let me have a moment, Your Honor. I don't have any further questions.
Thank you, Cross.
Yes, Ms. Sherman. Morning, sir. How are you?
Fine, sir.
How long have you been in law enforcement?
Since 1992,
Okay. Pretty much a career for you?
it is.
And do you enjoy doing what you do?
Very much.
Did you get any college training or anything before going to the police academy?
Well, not before the police academy. I had, right out of high school, I went into the Army. I was in the U.S. Army Infantry. And when I got out, I then applied directly to the Daytona Beach Community College Police Academy.
Completed that and then been in law enforcement ever since?
Correct.
And you've discussed your career with George Zimmerman, have you not?
In detail.
And it was actually you who assisted him when he decided that he needed a firearm, correct?
That is correct.
And did he tell you the reason why he wanted to get a firearm?
He asked whether he should or shouldn't to start with.
Okay.
And I recommended that he should, that
Okay.
anybody who's a non-convicted felon should carry a firearm.
That's your sort of life philosophy?
That's my opinion, correct.
Being armed is better than not being armed?
The police aren't always there.
And you then encouraged him to do that?
I told him if he wished to go and go to a place that actually trains for the concealed weapons permit and to get that training.
Which you know that he did, right?
He did do.
And that he actually got his concealed weapons permit?
I believe him and his wife.
Okay. And then they need to decide what weapon that they should or he should purchase, correct?
That is correct.
And did he seek your counsel in that regard?
He did.
And
Object is to beyond the scope of direct.
Sustained.
okay. Let's focus then a bit more. How long did you know George?
About 5 years. At that time, it was little, about 4 years at that time.
Okay. And I think you said he's your best friend?
Best one I've ever had.
Would that affect in any way your testimony here today, that he's a good friend of yours?
Well, not as far as the truth is.
Okay. So you're going to speak the truth, good or bad, for Mr. Zimmerman?
Correct.
And as part of that friendship, you were contacted on the night that this event happened?
I was.
Okay. And offered your help, went and I guess helped Shelley, who was going through what she was going through, right?
Near hysterical. She had called me she was visiting her father's home at the time when she received a call from a neighbor from Twin Lakes. And then she immediately called me. And both of us got into our vehicle and arrived at Twin Lakes about within 10 seconds of each other.
And how upset was she?
Indescribably hysterical. She had almost no information to go on because the neighbor, I guess, that called, they had to hang up. So she couldn't get further updates as to George's health or status or what he had. She was, I put my arm around her just to kind of keep her from blacking out, I guess.
Because at that point, she had gotten a phone call from somebody who actually said that George was involved in a shooting, correct?
She told me that she got a call that said George was involved in a shooting, in handcuffs, and bloody.
So you arrive at the area, the complex where it happened, meet with Shelley.
Correct.
Did you see George at that point?
We walked up to where the yellow crime scene tape was that was surrounding. It was a massive area that they had circled off, so we couldn't get very close to the actual scene itself. But inside the crime scene tape was a Stanford police officer car. In the back seat of the police officer car, Shelley and I saw someone who she more quickly identified as probably being George lean his head down and lay down from the back seat. And he supposedly he had laid straight down to where no one could see him.
And did you have any contact with him at that point?
None. Couldn't get anywhere close.
Okay. Then at some point you went to Sanford Police Department, correct?
Correct. I drove Shelley over to the Sanford Police Department and we waited in their lobby until he was released.
Do you recall about how many hours you were there?
Goodness. 2 or 3 a.m. Could have been even longer.
What was his state of mind when you finally saw him at 2 or 3 o'clock in the morning?
Stunned. He immediately attempted to reassure Shelley, who broke down again once she saw him. Once they got out of the elevator, she went into hysterics, kind of a breakdown, maybe not hysterics, but went into a sobbing breakdown. And he immediately tried to reassure her he was okay, and so he was more occupied with her than with anything else. But he had a stunned look on his face.
And when you say stunned, tell the
wide-eyed, just kind of a little bit detached, perhaps from maybe not realizing he had just gone through a traumatic event. Odd to describe, very, very difficult to describe it.
Let's talk about, obviously, as a good friend for him for the 5 years prior, or 4 years prior, you've known him, correct?
Oh, yes.
And then tell the jury, if you would, how he was that night compared to the George Zimmerman you knew most other days.
That's what I was using to base my observation on, was a more wide-eyed stare. Again, once he saw Shelley, he focused more on making sure she was reassured and that letting her know that he's okay, he doesn't have anything fatal or anything going on with him. He's all right. And she immediately started to observe. Once she got out of her shock at seeing George, she then started kind of looking at his injuries, and I guess she kind of went into nurse mode at that point because she was a nursing student.
And again, how is George presenting himself to you?
Detached. It's hard to describe.
Well, is detached different from the way he normally is?
Oh, vastly.
So when you say detached, what do you mean?
I would say probably when you feel like you've, it's hard to describe, sir. I would say he was probably in a position where he was not able to process. His mind wasn't. He wasn't answering questions, because I started asking him some questions about whether he needed to sit down for a little bit, right there in the lobby, and he didn't. He just, no, I just want to go. I just want to go home, kind of thing. And it was very basic. I don't know how to really describe detached, as in wide-eyed and really not processing what was going on.
Did he seem to you to be non-emotional about what was going on?
Coming right off of the elevator, he was tending to Shelley and her sobbing and her crying. So he was focused with that. When that went down, when Shelley actually transformed from a wife concerned for her husband to being a nurse, that's when he kind of had a blank stare.
And then at some point you guys got in the car, correct?
Went to my vehicle, correct.
And then let's talk about the conversations that he did have with you. So
right.
Give us the setting, if you would, as to how this conversation that at some point in the future you relayed as far as your direct examination. So sort of give us the setting for what happened.
Okay. We get into my vehicle. Both Shelley and George got into the back seat. I had a four-door vehicle. They both got in the back seat, and Shelley is trying to put an assessment on the injuries that were to George's nose, the back of his head, and he had a swelling on his left side of his head. It was about the size of your fist. It was a swollen area, not really a goose egg, not as pronounced as that, but it was a very big swollen area. I'm sorry, and with his head being his hair being closely cropped like mine, you could see it very well. I guess if he had a lot more hair, he would not have been able to see it as well. But she started tending to that, stating that we needed to get ice on it and such. And when we got stating that she needed to get ice on that part of the swelling, and on the drive from the Sanford Police Department to my home, he explained from start to finish. It took about the whole time that we went from the Sanford Police Department to my home. He explained what had happened that night, because that was the first time we had known any details of anything.
Now, as he was explaining it to you, was this sort of as a friend recounting to a friend, or were you acting in law enforcement mode or as friend mode?
Well, my wife will tell you it's hard for me to get out of law enforcement mode sometimes, but I like to analyze everything I hear to make sure that it makes sense. But I would say part of his friend also.
Okay. So let's start off then, not to belabor too much with keeping in mind your direct testimony, but let's start with, he first told you he was on his way to Super Target?
Correct.
Did that seem usual or unusual to you?
Every single Sunday like clockwork.
And tell me what he said to you about him first noticing who later became known to all of us as Trayvon Martin.
He observed Trayvon walking between two sets of townhomes and looking into, I believe there was a window to one where the light was on, and you could see that someone was looking into the window of a townhome. And it was about that time that Trayvon and George made eye contact with each other, and both aware of the other's presence.
Okay. And in that initial contact, did he seem to you as though he was angry or anything like that with who this person was?
No. George said that he wanted to make sure that he just got with non-emergency dispatch and had them send a police officer.
And he told you he did that?
Immediately.
And of course, you know from your conversation with George that that entire conversation was recorded, correct?
Yes, I do.
And from your conversations with George, both about this night and other nights, George Zimmerman certainly knows that those phone calls are recorded, correct?
Yes.
So tell me then, again, he's explained to you that Trayvon Martin is now walking up and sort of near his vehicle at some point?
Correct. Came walking from between the townhomes down to where the sidewalk or or the road area was.
And are you taking any notes at this point, or are you just listening to him download?
I'm driving.
Okay. So at some point, it became apparent to you that Mr. Zimmerman had stopped his car by the clubhouse, correct?
Yes, he did.
And that Trayvon Martin then came up towards his car, either looked in a window or walked partially around it?
Very close, walked around it, very close. They made eye contact several more times, very aware of each other's presence.
During this point, this sort of second eye contact, did George Zimmerman relate to you in any way that he was angry or anything about Trayvon Martin or this person who was there?
No, not at all.
And he further told you that he was still on the phone, of course, with non-emergency, right?
He remained on, correct.
So then we move forward to, I think you said that George Zimmerman did what he thought he should to keep Trayvon Martin in sight?
Correct.
Is that pretty much the way? Tell me how he related that part to you, as best you can recall.
Well, he said that he had heard from the Sanford police officers that showed up to the clubhouse to give instruction to neighborhood watch people was to always try to keep whatever subject that you're observing in sight. It makes it much easier for a law enforcement officer to show up and make contact with the subject if you're on the phone with dispatch during the whole process and you can actually see the subject.
Did he relate to you that the non-emergency dispatcher had actually told him on a couple of occasions, tell me what he's doing now or let me know if he's doing anything else?
He told me what he was doing. He didn't tell me that the dispatcher had said certain things.
Okay. So basically, George Zimmerman, as he's telling you this story, is recounting to you actions, correct?
Yes. Oh, yes.
Not necessarily, I did this because of this reason, or I did this, and sort of superimposing the conversation he's having with the non-emergency onto your conversation.
No, not at that time, no.
Okay. He was just saying basically a rendition of what was going on.
Correct.
And just so the jury is clear, about how long was this conversation between George Zimmerman and you during this car ride?
The drive from the Sanford Police Department to near the intersection of Reinhardt Road and Lake Mary Boulevard, which would have been about 14 minutes, 15 minutes.
And during that time, were other things being discussed as well, like whatever Shelley was doing with him?
She didn't interject at all.
Okay. So during this conversation then, he's telling you that he's trying to keep an eye on Trayvon Martin however
Correct.
he can.
That was
correct?
his intent, was to keep him under observation.
And at some point, well, tell me then, at some point did he say to you that I couldn't see him any longer, or that he lost sight of him?
That is one of the reasons why he got out of the vehicle.
And tell me how he related that to you?
He said he went in between the sets of townhomes down a dog path, a walking path.
When you say he, you mean Trayvon Martin?
What? Right. He lost contact in the darkness in between the townhomes down that walking path, and then he got out of his vehicle it may have been at the time when someone was asking him, where's your exact location, because the officer was getting close. So as the police officer gets closer and closer to the actual scene, the dispatch likes to tell them exact street numbers so you can find your place exactly.
Okay.
So that's what he was looking for.
George Zimmerman never told you during the entirety of this conversation that George Zimmerman ever went down the dog path, correct?
He did. He left his vehicle and he
walked down the path.
Walked down the path, correct.
Do you know this area that we're talking about?
I do.
Okay. And you know there's a path that goes straight through to Retreat View Circle?
Correct.
And then a right turn that goes off to the right?
Correct.
A T.
Yes.
And he had said to you that Trayvon Martin went down the T, correct?
Perhaps, yes. That's what he believes, because the street beyond was lit better than the dog path was. So if Trayvon had gone all the way to Retreat View Circle, he would have seen him or his shadow, perhaps. Because he lost sight of him around the time where the T was, he said, I believe he made his turn down that dark dog path area that was not very well lit at all.
and tell us the path, if you recall, that George Zimmerman told you he took as he was on the phone.
He said he went straight to go through since he lost contact. He wanted to go straight through to get a house number of one
Straight
of the
through,
straight
straight on the
through
path.
straight through, not take the right to go down on the T, just to go straight through and find some kind of a house number, because you want to make sure you get the exact house number, because there was a lot of units there on Retreat View Circle. The exact house number would have brought the police officer faster. I believe that's what his intent was.
And he told you that he was on his way back when the altercation began, correct?
Correct.
And that they said whatever they said to each other, as you testified to. Just to fast forward, I think you said that you weren't taking notes during that event, correct?
I was driving, correct.
Have you ever talked to George again about the facts of this case, or was that the only time?
One other time, I heard him relay the incident.
And when was that?
The next morning.
Okay, and we'll talk about that in a moment.
Okay.
During the event in the car, when he said things like, "Do you have a problem? You do now," or "No, I don't," are those, as best you can recall, the words that George told you he remembered from the night before?
That is correct.
And talking about the actual mounting, when he said that Trayvon Martin had mounted him, I think he said that at one point he was straddling and the knees may have been up as high as the armpits. Is that correct?
Could have been. The ribs area could have been as high as the armpits.
Well, no, I'm just asking
Yes.
you, because what I would like to do is have you tell the jury, without presuming or suggesting ribs, armpits, hips, knees, whatever it might be, for right now, just recount, as best you recall, what George remembered of the event and what he told you.
Well, I guess during a struggle, I guess the position of his knees and legs would probably change with George squirming. So at one point, I believe they were around his ribs, with George trying to squirm off of the sidewalk and onto the grass. I guess his knees came up a little higher, and that's very possible. Or the other way around, to where it was as he's squirming, once they get closer to the grass, in a fight, I guess, or in a scrap like that, it began at least here with the ribs, where the knees are somewhere in the ribs area.
Was he consistent, however, that it was Trayvon Martin who had mounted on top of him?
If it was Trayvon
Was it?
that did
Yes.
it? Oh, absolutely.
And was he consistent that it was he, meaning George Zimmerman, who was screaming for help?
Without question.
And he did tell you at some point that there was some hand over the nose, hand over the mouth event?
Correct. But it was raining and it was slippery, I'm sure.
Did he tell you how long that portion of the overall altercation lasted?
20 seconds maybe, 15, 20, 30 seconds.
Did
He didn't mention it.
Well, again, I don't want you to
No, he didn't mention
assume,
it. He did
but
not say how long.
Okay. Did that, however, as he related it to you, seem to be significant as it was occurring to him, that he couldn't breathe for whatever length of time?
Yeah, it was critical.
And that somebody had a hand, Trayvon Martin, on the nose that had already suffered the previous injury?
Correct.
And as he was relating that to you, was that sort of a real focus of his?
That was the focus. That when he was losing oxygen, he felt he was not able to breathe, and that's why he was desperate to either clear an airway.
And in your experience as law enforcement, would you agree that that's sort of a natural reaction to traumatic events?
I would think so, every time I've seen it.
And do people involved in traumatic events like that sometimes focus on particular parts of it?
Almost exclusively to the omission of others.
For example, a car accident, you might focus on the speed of the car coming at you and completely forget about other cars around you.
Correct.
Is that unnatural in your experience as law enforcement?
No, it's typical.
So when you go to a scene of an accident or shooting or just anything that you investigate, do you find in your experience that people often have sort of tunnel vision views of what happened to them?
Sometimes very specific, correct.
Does that mean that they're lying to you when they do that?
Not at all.
Why not?
It's been proven that is typical. Sometimes they'll focus in on one event to the exclusion of others.
How about their ability to just recount events with any particularity at all.
I'm going to object this beyond the scope of direct. I haven't objected previously.
It's the same.
And then you testified concerning this whole event around the gun. Did you have a similar concern as to Mrs. Zimmerman's ability to recount those events to you?
No.
Okay. Tell me what he did say about having to grab his gun.
He said that Trayvon had reached down and grabbed for the gun, whether it was on the leather holster or on the actual metal part itself. At the time, I didn't see a difference. I just thought that the intent was clear, and that's when he had to. He freed one of his hands and went and got the gun. He either broke contact or knocked somebody else's hand away, or Trayvon's hand away from him reaching for the gun or grabbing the gun, and then he drew it.
Do you recall if he even told you that Trayvon Martin had touched the gun, or just said he was reaching for it?
I thought he had said he had grabbed the gun. I've only heard the story twice, and whether it was grabbed the gun, grabbed for the gun, perhaps it was just the intent. But I believed he said he grabbed the gun.
So, and then he told you the rest of the story as you related, correct?
Yes, sir.
About Trayvon Martin sort of saying something to him. Did that seem unusual to you, that someone shot could still say something?
Yes. Oh no, that's very, very common. Unless you're shot in, let's say, the windpipe and in the vocal cords, you would be able to talk for maybe 6 to 8 seconds.
Nonetheless, that George Zimmerman said that he had gotten off and actually held his hands out away from his body.
He had gotten off of George, laid down on the grass, and George had jumped on top of him to pin his hands down and to, again, try to solicit some help from people that are around.
And yet, when he let the hands go, Trayvon Martin may have brought them back under him. Was that the way it was presented to you?
No.
Speculation.
Oh, yeah.
I apologize, I withdraw it.
Yeah, no.
Okay. Did he even did George Zimmerman even know to talk to you about the fact that Trayvon Martin's hands were found back under his body?
I did not know that fact.
Okay. So he didn't seem to feel any need to explain that away to you, correct?
Correct.
So now let's talk about your recounting this. Well, you said that you heard a story again the next day.
Next morning.
Any differences in what we've talked about so far?
None.
Okay. And who was that discussed with or in front of?
My wife and his wife, Shelley.
And was it different in any context when it was being discussed then?
George looked different. He was not as wide-eyed, and he did not appear to be as in shock the next morning.
Now, let's fast forward. How many months until you decided to recount this in a book form?
I have to look. At least 4 months.
Okay. Did you have any conversation with Mr. Zimmerman to corroborate that what you recalled happened, or what you recall him telling you happened, was in fact accurate?
We were not able to contact each other after he was arrested the first time. So there was no contact.
All right. And so you haven't talked to him, you haven't shown him, for example, a draft of the book and say, I remember you saying this, and him saying, no, that I said this instead.
There was no cooperation with that, no.
Yeah. This is your memory 4 months later when you looked back to that night, correct?
Correct.
And just remember it as best you can 4 months later.
Correct.
You didn't take any notes that night,
None.
nor in between, did you?
No.
So it wasn't until 4 months later that you went back, sort of scoured your memory to put back together what he had told you on that night, 2 o'clock in the morning on the 27th.
Unfortunately, I did not take any notes, so it was just memory.
Okay. if you had any facts wrong that were conclusively proven wrong by forensic evidence, would you defer to the evidence rather than your memory of it?
Without question.
If, for example, he told you he shot once and there were 4 shots fired, and you had in your book that there was 1, but the forensic evidence supported 4, you would defer to that?
I'd support that 100%.
And to the extent that he may have told you something, well, you remember he told you something differently than it appears in the non-emergency call, which was recorded contemporaneous with the event, you would defer to that?
Absolutely. I may have heard wrong, or I may have documented it wrong.
And even if there was something different that he told law enforcement a few hours earlier in a recorded or videotaped interview from what you recall happening, would you defer to that?
I would.
A moment, Your Honor. And at some point during this investigation, you had an opportunity to listen to the screaming on the 911 call, correct?
The honor still doesn't work.
Sustained.
Then no other questions from me.
Any redirect?
You, as best you could, have testified and have written in your book what the defendant, your best friend, George Zimmerman, told you, correct?
Correct.
You haven't made anything up to help one side or the other, is that correct?
None whatsoever.
And as you stated, the defendant never told you that the victim had his hands underneath his body after he shot him. He said he put his hands out, right?
Correct.
Okay. And as you stated, the defendant told you that the victim, Trayvon Martin, grabbed his gun, correct?
Yes.
Okay.
Grabbed for his gun.
Well, I think you actually...
Grabbed, right. Whether it was, again, I guess we're going over whether he grabbed the holster part or the gun. I didn't see a difference in the two, but grabbed something.
Grabbed the gun. He didn't...
Absolutely. The gun didn't come out,
No.
but he grabbed the gun in the holster.
That's what I'm saying.
Yes, sir.
The defendant didn't tell you, Mr. Zimmerman didn't tell you he grabbed for it. He said he actually got it.
That's what I heard. That's what I thought I heard, yes.
Right, okay. Then he told you, I thought I shot wide, but he might get up, so I put my gun in my holster.
Correct.
Then he said he put the phone in his pocket, turned around to head back, and the guy was right there about 15 feet walking towards him.
Correct.
Thank you, sir.
Thank you.
Very brief, one question in response. As to the reholstering of the weapon, do you recall if he told you that it was reholstered as he got up, if he had it in his hand when he was holding Trayvon Martin's hands down, or even at some point shortly thereafter?
He may have had it. He may have had it still in his hand as he jumped on top of Trayvon, and perhaps holstered when he saw the flashlight. I don't remember specifically when exactly he holstered his firearm.
Thank you. Nothing further on.
You wrote in the book that he holstered his firearm.
He holstered his firearm at some point. Exactly when, I'm not 100% sure whether it was when he got up from, whether he stood up and reholstered, or whether he holstered while still partially on top.
All right, you want to look at your book a minute, if you could, page 29 at the bottom. Did you quote him as saying, in fact, I thought he might try to get up again, so after putting my gun in my holster, I jumped on top of him and pinned his wrist to the ground?
Correct.
Okay,
What-
was that accurate?
As far as I remember, that he holstered, yeah, at that point, it now remembers that, I remember that it was, he holstered, pinned his hands down. It's what I remembered him saying something like that.
Thank you, sir.
Thank you. May Mr. Osterman be excused?
To remain under our subpoena, Your Honor.
Okay, thank you. You're excused from the courtroom, but you're subject to being recalled. Okay, thank you very much. Ladies and gentlemen, we'll go ahead and take a recess for lunch. Before you go to lunch, I'm going to advise you that during lunch, you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to go on the internet by using any type of an electronic device to do independent research about the case, people, places, things, or a terminology. And finally, you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have your assurances that you will abide by these instructions? Okay, thank you. And with that, put your notepads face down and follow Deputy Jarvis into the jury room. I didn't say what time we were going to come back, so it'll be 1:30. Anything we need to take up before we recess for lunch? Okay, thank you all very much. We'll be at recess till 1:30. Please be seated. Court is back in session. Are we ready to bring the jury in?
Yes, Your Honor.
Okay, let's go ahead and bring them in.
Next witness is going to be actually the plaintiff of the Hannity interview. We had an instruction prepared regarding that redaction. I've got my copy here.
I'll take your copies, fine.
Yeah.
It should be this right here. You're welcome. Please be seated. Welcome back, ladies and gentlemen. I hope you enjoyed your lunch. During the lunch hour, if your answer is yes to any of my questions, please raise your hand. During the lunch hour, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to go on the internet to do independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. Mr. De La Rianda?
Your Honor, at this time we would formally play the Hannity interview on July 18th, 2012. And I think there's a preliminary instruction, of course.
Yes. Ladies and gentlemen, at the direction of the court, certain portions of the defendant's interview with Sean Hannity on July 18th, 2012 have been excised or redacted based upon legal determinations made by the court. The parts excised or redacted are not relevant, and you are not to concern yourselves with why this occurred or with the content of any excised or redacted portions. You may proceed.
Thank you, Your Honor. This will, for the record, states Exhibit 180.
And tonight, in an interview that you will only see right here on Hannity, George Zimmerman, the man charged with second-degree murder of Trayvon Martin, breaks his silence. Now, earlier today, I traveled to Seminole County, Florida. Let's go back to the night of the shooting. Take us back to that night. You were going to the store. Let's start at the beginning.
I was going to Target to do my weekly grocery shopping. Sunday nights was the only nights, well, Sunday after we mentored the kids, we would always go grocery shopping and do our cooking for the week. So I wanted to go to Target, and I headed out, and that's the last time I've been home.
Since then, you never went back since that day. Then we all have heard the 911 call. On that 911 call, you had mentioned that there had been a number of break-ins in the neighborhood. Why were you a community watch person? How long were you involved in that, and why did you become a community watch person?
In August of 2011, there was a home invasion. A young lady was home with her 9-month-old baby, and they broke in her sliding glass door. She barricaded herself in the upstairs bedroom, and my wife was home by herself, and she saw the people that burglarized her run through our backyard with their belongings. And even though my wife wasn't certain what happened, that was enough to scare her and shake her up. And I promised her I would do what I could to keep her safe.
Your gun was legal. You had a legal weapon in the state of Florida.
Yes, sir.
Why did you feel the need to carry a gun? A lot of people maybe have a weapon inside their home, but you decided to carry yours. Why did you think it was necessary to have a weapon with you, and did you carry it at all times?
I carried it at all times except for when I went to work.
Yeah. A lot of this case legally has to do with stand your ground. You've heard a lot about it. And I was just curious, prior to this night, this incident, had you even heard stand your ground?
No, sir.
You'd never heard about it before?
No.
Wow. Now, it was very interesting, in the 911 call that everybody has heard, you said that all of a sudden you found somebody who looked suspicious. He may be on drugs. That was one of the earlier comments that you made in that 911 call. What made you think he was suspicious, and what made you think that he might be on drugs?
I felt he was suspicious because it was raining. He was in between houses, cutting in between houses, and he was walking very leisurely for the weather. It didn't look like he was a resident that went to check their mail and got caught in the rain and was hurrying back home. He didn't look like a fitness fanatic that would train in the rain. He just seemed like...
Weren't there overhangs, though? He was walking, he wasn't standing still? And he was walking closer to the house, which is back from the sidewalk?
Yes, sir.
Am I understanding that right?
The overhangs are just in front of the front doors.
Yeah. You said he started from almost the beginning in that 911 call. You said he came towards you, and he seemed to reach for something in his waistband. Did you think that was a gun?
I thought he was just trying to intimidate me.
To make you think that there's a gun?
A weapon.
Of some kind?
Possibly.
You said in that tape, something's wrong with him, he's checking me out, I don't know what his deal was. So it's almost from the very beginning, you felt, are you saying on that 911 tape that you felt threatened at that moment when you said that to the dispatch?
No, not particularly.
What did you mean with, I don't know what his deal is, he's checking me out?
The way he was coming back, and I was on the phone, but I was certain I could see him saying something to me, and his demeanor, his body language was confrontational.
Do you remember what it was that you said specifically on the tape? Yeah. You said, then we get to the issue where you said on the 911 call that he's running. You said that to the dispatch. Is there any chance in retrospect, as you look back on that night and what happened, trying to maybe get into the mindset, because we also have learned that Trayvon was speaking with his girlfriend supposedly at the time, that maybe he was afraid of you, didn't know who you were.
No.
You don't think that? Why do you think that he was running that?
Well, maybe I said running, but he was more.
You said he was running.
Yes. It was like skipping and going away quickly, but he wasn't running out of fear.
You could tell the difference?
He wasn't running.
He wasn't actually running.
No, sir.
Okay, because that's what you said to the dispatchers. You thought he was running. And let me ask you this. At that point, we can hear the unbuckling of the seatbelt, hear you opening the car door, and the dispatch asks you at that point, and this became a very key moment that everyone in the media focused on, and the dispatcher asked you, are you following him? And you said yes. Explain that.
I meant that I was going in the same direction as him to keep an eye on him so that I could tell the police where he was going. I didn't mean that I was actually pursuing him.
So this moment where some had suggested you were out of breath on that tape, you yourself were not running.
No, sir.
And you, I think, made a statement to the police that it was the wind as you were getting out of the car and moving, and that was the sound we hear, not you out of breath.
Yes, sir.
And welcome back to Hannity. We continue now with more of my exclusive interview with George Zimmerman and his attorney, Mark O'Mara. What did you do from that moment forward? Because this is where we get into this minute gap in this case. You know, and what did you do from that minute forward when the dispatch said, we don't need you to follow him? What did you do next?
I walked across the sidewalk onto my street, Retreat View Circle, where I thought I would meet a police officer that I had called.
So you did not continue to follow him at that point?
No, sir.
All right, so you continue from there. You sounded at that moment on the tape, though, a little bit distracted. What was the distraction? That you were looking for him, or?
I wanted to make sure that, I believe they asked me for my address, and I wanted to be sure that nobody was lingering and could hear my address and then come back. And I was making sure that there wasn't anybody that was going to surprise me, and just trying to give them an accurate location.
Because they said, you know, can we meet you here at a certain location? You said, have them call me.
Yes.
Why did you want them at that point to call you?
I hadn't given them correct address. I gave them the clubhouse vicinity. However, I was walking through to my street, Retreat View Circle, and I was going to give them the actual street number and name.
How long was it, George, after that you saw Trayvon again? Because you said you stopped, that you did not continue pursuing him. When did you next see Trayvon Martin?
Less than 30 seconds.
Okay. Where exactly were you at that point? And how far away were you from your car at that moment?
I'd guess about 100 feet or more.
So you never went further than how far approximately from your car?
I'd estimate it to be approximately 100 feet.
So you never went further than that from the car?
No, sir.
Okay. And so at that point, Trayvon is, all of a sudden you turned around and there he was?
Yes, sir.
What happened next?
He asked me what my problem was.
Expletive problem.
Yes, sir. And I was wearing a rain jacket, and I had put my cell phone in my jacket pocket as opposed to my jeans pocket where I normally keep it. And I immediately went to grab my phone to this time call 911 instead of the non-emergency. And when I reached into my pants pocket, because that's where I keep it out of habit, it wasn't there, and I was shocked. I looked up, and he punched me and broke my nose.
One shot.
Yes, sir.
So he said to you, you have expletive, you have a problem. Those were the exact words you used. You remember it?
Do you have a problem? What's your problem?
What's your problem? And you said to him, I don't have a problem.
Yes, sir.
You reached for your phone.
I reached for it as I was saying, no, I don't have a problem.
And at that point, you just got hit?
He was already within arm's length from me.
And was that the punch in the nose that broke your nose?
Yes, sir.
right there, and you went immediately down to the ground?
I don't remember if I went immediately to the ground or if he pushed me to the ground, but I ended up on the ground.
What do you remember happened from there? Because there were police reports and descriptions that you gave, and that you were a little bit dazed, obviously. And at one point you said that you wanted to stop him from hitting your head on the cement.
Yes, sir.
Is that what you told the police?
Yes, sir.
Okay, so after that first hit, what happened next?
He started bashing my head into the concrete sidewalk. As soon as he broke my nose, I started yelling for help. So I was disoriented, and he started slamming my head into the concrete.
Which is where the lacerations came from.
Yes, sir.
You said it was like your head was going to explode, was a comment that you had given to the police.
Yes, sir. He continued to punch me in the head.
How many times would you estimate that he punched you?
Several. More than a dozen.
And hitting you hard. At what moment did you, because you said you feared for your life, at what moment do you remember when you literally, do you remember when you thought, I may die? Is that, because you said that you felt you feared for your life. Do you remember the exact moment when you felt that?
In hindsight, I would say when he was slamming my head into the concrete and I thought I'd lose consciousness. I didn't know what would happen at that point.
And how close was the concrete to the grass? Because a big issue is also the grass stains that you had on your clothes. And you had made a statement to the police that you wanted to get to the grass. Was that to protect your head from getting banged into the cement again?
Yes, sir.
How close was that in proximity?
It butts up to the concrete.
And were you able to get to the grass?
Yes, sir.
And how did you do that?
I guess you could say shimmy. I mean, he was straddled on me with his full weight, and I would try and sit up and push myself down. And whenever I would sit up, that's when he would take the opportunity to slam my head back down and punch me in the head and continue to hit my nose.
Was he talking to you a lot during this fight, when he was beating you? Because you're saying he's beating you and pounding your head into the cement. Was he talking to you during that time?
Yes.
And he was saying?
Cursing, telling me to shut up, and then finally telling me he was going to kill me.
And he said those words. And he said it. When did he first see your gun?
After we were on the ground, I shimmied with him on top of me, and it made my jacket rise up. And he being on top of me saw it on my right side.
What happened after that?
I felt him take, he had, after he couldn't hit my head on the concrete anymore, he started to try to suffocate me. And I continued to push his hands off of my mouth and my nose, particularly because it was excruciating, having a broken nose and him putting his weight on it. And that's the point in time when he started telling me to shut up, shut up, shut up.
Why did he tell you to shut up?
I don't know.
We heard the screams on the one recording from a neighbor that was calling the police, and there's been some dispute whose voice that is. Was that your voice screaming, or was that Trayvon Martin's voice screaming?
That was my voice. Absolutely.
That was your voice?
Yes, sir.
And the police even said at one time they heard 14 screams. You were screaming that loud?
Yes, sir.
And you said to the police at one point that he put his hand over your mouth. Do you think that was to silence you from screaming?
Yes, sir. I believe he, from what the investigators told me, he knew that I was talking to the police, and I was yelling so that I believed that the police officer was there, and they just couldn't find me. So I was yelling in the hopes that they were in the vicinity and they would come when they heard me yelling.
Do you remember when you yourself reached for your weapon? Do you remember that moment?
Yes, sir.
Tell us about that.
At that point, I realized that it wasn't my gun, it wasn't his gun, it was the gun,
Did he say anything? Because you said he was talking a lot about the gun. Did he say he noticed the gun?
He said, "You're gonna die tonight," and took one hand off of my mouth, and I felt it going down my chest towards my belt and my holster, and that's when I didn't have any more time.
Do you think you acted more out of a conscious thought? I mean, I know these events happen very quickly. Do you remember consciously thinking, I've got to grab my gun? Or did you just do it? Was there a conscious thought that went through your head that you thought you were going to die and that you had to take this, you had to get your weapon and fire?
I'd love to give you an answer.
You don't know.
It just happened so quickly.
Mm-hmm. Now, there was an eyewitness that was out from the very beginning that, in fact, did tell the police the night of the shooting that he saw Trayvon on top of you and did see the beating. There is no witness to the actual shooting itself. Right? Correct?
Besides myself.
Besides yourself.
Yes, sir.
When you think back, and there was one report or a police report that actually said you didn't know after you fired, you thought you missed?
Yeah, I didn't think I hit him, yes.
Yeah. So what happened immediately after the shooting then, George? I understand one guy came out, he said he had a flashlight, that he spoke to you, and you said to call your wife, tell her what happened, that I shot somebody. Do you remember that conversation?
The conversation I had with the gentleman, or?
Yeah.
Yes, sir.
You do remember that conversation. And he did talk about it, and what his suggestion is that you were very matter-of-fact about it. Do you remember what you said to him? Do you think you were in a state of shock? When did you know that Trayvon had died?
When I went, probably about an hour after I got to the police station.
After the shooting, you saw that he was laying there and obviously injured. There was a moment where you realized that he was shot.
Like I said, he sat up and he said something to the effect of, "You got it," or "You got me." I assumed he meant, okay, you got the gun, I didn't get it, I'm not going to fight anymore. At which point, I got out from under him.
Is there anything you regret? Do you regret getting out of the car to follow Trayvon that night?
No, sir.
Do you regret that you had a gun that night?
No, sir.
Do you feel you wouldn't be here for this interview if you didn't have that gun?
No, sir.
You feel you would not be here?
I feel that it was all God's plan, and for me to second guess it or judge it.
Is there anything you might do differently in retrospect now that time has passed a little bit?
No, sir.
You know, the detective said, that Detective Singleton said, he quoted you saying, the bad guys always get away. You also said that in the 911 tape. Did you have a feeling that there were a lot of people that do get away with crimes? In other words, were you sort of predisposed in your mind in some way to think that criminals get away too often?
Not in general. I think in our neighborhood, there's geographic advantages for burglaries.
Do you have any idea, why do you think Trayvon would have confronted you the way he did? I made a comment on the air one day, and I got beaten up pretty bad for saying this could have all just been a terrible misunderstanding or a mistake. Do you think maybe, is there any possibility he thought you were after him and you thought he was after you, and there was some misunderstanding in any way?
I've wrestled with that for a long time, but I can't. One of my biggest issues through this ordeal has been the media conjecture, and I can't assume or make believe.
The one witness that you first met, the guy with the cell phone that I mentioned, asked about your demeanor right after the shooting. He was the first person, I guess, on the scene?
Yes, sir.
First person you saw. And he said that you looked like you had been, quote, butt-whooped, like you had a fight, and that you were asking, call my wife, just tell my wife. But, he was acting like it was nothing. Is that how you were feeling at the time? Because you didn't find out, you said, till later that Trayvon had passed away.
No, I knew that I had discharged my firearm, and I was scared, nervous, I also thought the police were going to come and see me with a firearm and shoot me. I mean, I was terrified.
Did you look over at Trayvon? You obviously at some point recognized he had been shot because you didn't know it in the beginning. Did you look over at him at any time and realize he was in really bad shape?
No, sir.
At no point. And how long was it between the time you shot him to the time the police actually got to the scene?
It felt like forever. I'd say 15 to 30 seconds.
It was that quick?
Yes, sir.
Immediate. So in other words, they had already been on their way and they were there within 15 and 30 seconds. What do you make of all the national media attention in this case? There are crimes that happen every day. The nation is focused on your case. Why do you think that is, and what do you make of it? And what does it mean to you?
It's surreal. I don't like that they've brushed to judgment the way they have. I feel that anytime they have a story that's remotely positive, they interpret it negatively.
You had called police on at least 4 prior occasions and had mentioned black male suspects. I wanted to give you a chance to respond. Why you called? What were those instances about?
They also stated that, and I never volunteered that information. It was always at their request that I described them, and even when I described them, I didn't volunteer the race until they asked me. And there was also Hispanic kids and white kids that were in the neighborhood.
That you made calls about?
Yes, sir.
Let me ask you this. I want to go back to one specific in the case, if I can. And it's the issue of you following him. And we heard, asked you earlier about the dispatch call, and you said you stopped, you didn't follow him. There's one moment that you were apparently, as you look at the grounds of where this took place, and there's the apartment, and there's the overhangs, and then there's another street on the other side, and you had gone to the other street, correct?
Yes, sir.
At some point. So how do you get to the other street if you're not following him? I mean, where were you going at that point?
I was walking from where I had parked my car towards my street. He went right down in between the houses. I walked straight across to.
But in that sense, were you following him?
No, sir.
You weren't following him?
No, sir.
And this is after the 911 call? During the 911 call?
When they stated, we don't need you to do that.
So why were you walking back to your street and not back to the car?
I was
at that point. If I'm trying to get the chronology right.
Certainly. Where I parked my car was the back of townhouses. There wasn't a way to know what the street number was. And I knew if I walked straight through, it's a circle, Retreat View Circle. I knew if I walked straight through to there, that would be Retreat View Circle, and then I could tell them exactly what 1, 2, 3, 4 Retreat View Circle, and not just a general area of where my car was like I had done previously.
Call your next witness, please.
Dr. Valerie Rao.
you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Good afternoon, ma'am. If you please tell the members of the jury your name.
Yes, my name is Dr. Valerie Rao. My last name is spelled R-A-O.
And how are you employed?
I'm the District 4 medical examiner.
And what comprises District 4?
District 4, we have 3 counties, Duval, Clay, and Nassau.
And are you the chief medical examiner in your district?
Yes, I am.
How long have you been a medical examiner in total?
32 years.
And are you also a licensed physician and surgeon?
Yes,
And how long have you been so licensed in the state of Florida?
since 1981.
Can you summarize for the members of the jury, please, your educational and professional background?
Yes, I got my degree in medicine in 1971, after which I went to London. I spent a year and a half doing pathology at 2 hospitals, one St. Heliers Hospital in South London and the other St. Andrews Hospital in East London. After which I came to the US and I did residency, 5 years totally. 2 years doing clinical pathology at Berkshire Medical Center, Pittsfield, Massachusetts. 2 years doing anatomic pathology in Albany Medical Center, Albany, New York. 1 year doing forensic pathology in Baltimore for the state of Maryland. I'm board certified in anatomic, clinical, and forensic pathology. I then spent a year in Tucson, Arizona, where I did medical examiner work. I was medical examiner for a year. 1 year as medical examiner. After which I went to Miami, where I was an associate medical examiner for a total of 19 years. I then took a chief position in District 5, where I was there for 3 years. I went to the University of Missouri in Columbia, where I was associate professor for 2 years, and then came to Jacksonville, where I've been here for about 7 years.
And just briefly, what are your duties as a medical examiner?
In the state of Florida, we are required to investigate sudden, unexpected, unnatural death, and ultimately to sign the death certificate, the cause and manner of death.
What is meant by the term pathology?
Pathology is the study of disease in the human body.
And what is meant by forensic pathology?
So in forensic pathology, it comes under the umbrella where the sudden, unexpected, unnatural death cases come under the forensic pathologist.
And have you ever been qualified as an expert in the courts of the state of Florida in the field of forensic pathology?
Yes.
Approximately how many times?
Hundreds of times.
Do you also have experience examining injuries to living people?
Yes.
And explain what that experience is.
Okay, so when I was in Miami, where I was an associate medical examiner, had the opportunity to work there at the Rape Treatment Center for 18 years, where I saw several thousand living patients, examination and treatment of these victims.
And what types of injuries would you see when examining those victims?
Okay, some of the patients that came were also physically assaulted. So there were injuries that come under the category of blunt force trauma. There were patients that were stabbed, so that's sharp force injury. Some of the patients were strangled but did not die. So we saw this gamut of cases in living patients.
And what are blunt force injuries?
So blunt force, the term is to distinguish it from sharp force, meaning that the instrument that's being used, for example, a bat would qualify as a blunt weapon. A stick, if I was to bump myself as I came in here on the corner of this table, I would suffer blunt injury if it was severe enough to cause injury. Whereas a sharp force is injury that is caused by a sharp weapon, a knife, a bottle that is broken and then the sharp edge used to inflict trauma. So this is the difference between sharp force and blunt force trauma.
Within blunt force trauma, are there different types of blunt force trauma?
Yes.
And what are those?
So the first part of it, let's look in progression of severity. A bruise, we're talking about a small bruise, is where the skin is intact and the blood vessels under the skin are injured and they bleed under the skin and get what you know as a bruise. The skin is intact. Then you have a scrape, where the skin is compromised and it's, for example, a rug burn would qualify as an abrasion. Then you have the lacerations where not only the skin is torn, but the underlying tissue is also torn, exposed to the outside. And depending on the severity of the laceration, you will get varying degrees of bleeding and trauma.
All right. Are bruises also known as or referred to in your field as contusions?
Yes.
All right. And then scrapes is the same as a laceration?
Abrasion.
I'm sorry, abrasion.
Yes.
And then there's lacerations.
Yes,
Okay.
which is basically, laceration is a tearing of tissue.
All right. Have you ever been qualified in the courts of the state of Florida as an expert in the area of conducting rape examinations and all manner of injuries associated with rape victims?
Yes,
And again, approximately how many times?
hundreds of times.
During your tenure as the medical examiner in Miami, did you also examine other categories or sets of living victims?
Yes.
And explain what you mean by that.
So, for example, somebody alleging police brutality, the medical examiner, we just were housed directly across a very large hospital in Miami, Jackson Memorial Hospital. So the police would ask if we could go and examine to see if the allegations were actually borne out by the trauma. So we would go across the street, we would photograph, we would put out a report, and those reports come under consultations. Also child abuse cases, especially if the clinical people thought that the child was going to die, they would ask us to come and take the photographs and do the interpretation. So we basically practiced forensic medicine, not really forensic pathology, where you're only looking at dead people.
At this time I would tender Dr. Rao as an expert in the area of pathology and forensic pathology.
I don't think that's necessary under the current case law in this state.
She'll be able to testify in those areas.
Thank you, Your Honor. Were you asked to examine some evidence in the state of Florida versus George Zimmerman?
Yes.
And specifically, what were you provided in regards to that case?
So I was given a whole series of things that I asked for the whatever is available, because I'd like to do the consult, having as much as possible in the database before I formulated an opinion. So what I received was a reenactment of the incident involving the fatal shooting. This was recorded on the 27th of February 2012. I got a set of 36 photographs taken of Mr. Zimmerman, documenting the clothing, the injuries, the medical records from the Altamont Family Practice Clinic. And of course, there were two records from this clinic. One was on the 27th of February, and the other one was on the 9th of March 2012. I got a DVD labeled Sanford PD Lobby and Others. It showed the vehicle going to the police department and Mr. Zimmerman being taken by the police into the department to be booked. A DVD labeled Medical Examiner Report and Photographs. And this included the medical examiner report, the body diagrams, the autopsy photographs. 26 autopsy photographs were taken, the toxicology report, and then a report that states two individuals were involved in a physical altercation in the yard, and one of them fired a handgun and the decedent fell to the ground. And the other items in the same folder were the medical examiner autopsy report, the toxicology report. So this is what I received.
Did you also receive two photographs of the defendant at the scene the night of the event?
Yes.
And when you said reenactment, when you referred to the reenactment, was that an interview where he conducted a walkthrough and led investigators through the scene and explained to them what happened?
Yes.
After reviewing all of those items, in terms of severity, how would you classify the injuries to the defendant's head?
They were not life-threatening. They were very insignificant. They did not require any sutures to be applied to Mr. Zimmerman. So, as I would refer to them, insignificant injuries.
Did you observe any lacerations to the back of the defendant's head?
Yes.
How many?
2.
And were those lacerations depicted in the photographs that you reviewed?
Yes, they were. There was bleeding, so I was not able to look at them after they were cleaned, because subsequently, when he went to the Altamont clinic, they were covered by Band-Aids.
And were you also provided the reports from the Altamont Family Springs Clinic describing the injuries as they were viewed by a physician's assistant the next morning?
Yes.
All right. Your Honor, would you assist me with the lights? Dr. Rao, let me show you first, state 79. Was that one of the photographs from the scene that you were provided?
Yes.
And state 76, was that a photograph from the scene you were provided?
Yes.
Let me show you states 57, where you also provided that photograph.
Yes.
All right. Your Honor, may I approach the witness? Yes, you may. Dr. Rao, let me give you this pointer. You just press that button. If you would explain for the members of the jury where the lacerations are located that you observed and that were referred to in the family clinic report.
Okay, so we have one small injury right there and one injury right there where the blood is streaming from. So these were the two lacerations.
All right. In the Altamont Family Clinic report, were you also provided with the measurements of each of those lacerations?
Yes.
And are either of those lacerations life-threatening?
No.
Why not?
Because they were so minor that the individual who examined and treated Mr. Zimmerman told him that the sutures were not required. So she put a Band-Aid on each of them, and that was the extent of the treatment.
All right. Are there also some contusions or a contusion on the back of the defendant's head?
Yes.
And can you show the members of the jury where that is in the photograph?
Right there.
And is that a life-threatening injury?
No.
Why not?
Well, the reason I asked for everything was I then looked at the entire case file, and when he walked from the police car to the police department to be booked, he was not incapacitated in any way. He was very alert and walking, in pace with the officers.
Are the injuries that you observed to the back of the defendant's head consistent with his head having made contact with a concrete surface?
Yes.
And why do you say that?
So, I've looked at the other areas that were photographed, and they have a sort of a pattern that were punctate, meaning that there were little areas which came into contact with a rough surface. But so looking at the concrete area, again, the reenactment that I was given, it's consistent with his head having come into contact with that rough surface.
And are the injuries on the back of the defendant's head consistent with one strike against a concrete surface?
Yes.
And why do you say that?
Because if you hit the head one time, it is consistent with having gotten those two injuries at that one time, because it's an area where it is protruding, because the head is protruding, because the head is a round surface, and so that one impact could result in the two lacerations that you see.
And are the injuries you observed to the back of the defendant's head consistent with his head having been slammed repeatedly into a concrete surface?
Okay, so I'm going to give you my what I think based on the dictionary definition of slammed is. And there are two definitions from two different dictionaries.
Let me object, Your Honor. If she's going to define a word from a dictionary, that would be hearsay.
Please approach.
May I proceed? Yes, ma'am. Dr. Rao, using your definition of slamming, your common understanding of slamming, are the injuries to the back of the defendant's head consistent with having been repeatedly slammed into a concrete surface?
No.
Why not?
Because if you look at the injuries, they are so minor that, to me, the word slam implies great force. And the resultant injuries are not great force.
What type and extent of injuries would you expect to see if the defendant's head had been repeatedly slammed into a concrete surface?
So if somebody's head is repeatedly slammed against concrete with great force, I would expect lacerations. I would expect a lot of injury that would bleed profusely, that would necessitate suturing. And so I don't see that in this picture.
All right, let me turn your attention to States 47, where you also provided that photograph.
Yes.
And what injuries did you observe in this photograph, States 47? If you would, just describe those for the jury.
Okay, so there is a small abrasion on the bridge of the nose right there. It's a very small little punctate at the tip of the nose.
Can you circle that with your laser, if you would, or just indicate it?
Right there.
Okay.
And right there.
And are any injuries in this photograph life-threatening?
No.
Why not?
He has no loss of consciousness whatsoever. He didn't have to go to the hospital. He went to a clinic.
Were there any contusions or abrasions that you noted in this photograph?
Yes.
All right, can you again show us where those are?
Yes. Right there and right there.
How would you characterize or classify the contusions, the severity of the contusions or abrasions to his face?
Very small.
Could all of the injuries that you observe in that photograph have come from a single punch or a single blow?
Yes.
And why do you say that?
Okay, so if you look at the distribution of where the injury is, and let's think that I'm the one inflicting the blow. If I was to punch myself right above here, I would get the injury on the nose and on the few contusions on the forehead. So one blow would be able to inflict these injuries.
Are the injuries that you observed to the defendant's face consistent with the defendant having been beaten a dozen times or more in the face?
If he was beaten repeatedly but with no resulting trauma on the face, then yes. But if the force is such that you get trauma, then only one time.
Did you observe contusions to both sides of the defendant's head?
On the sides, yes. Yes.
All right, let me show you State 75. Was that a photograph you were provided?
Yes.
And could you circle the area of contusion that you observed in State 75?
Okay. So one has to disregard this dried blood because it is coming from the laceration on the back of the head that I had demonstrated earlier. So we are looking at a contusion here. And there are very, very fine punctate abrasions that you need to have a close-up photograph to really see them.
And again, explain for the jury or define for the jury what's a punctate abrasion.
Okay, punctate means like a little speck, like a spot.
All right. Are any of the injuries depicted in State 75 life-threatening?
No.
And in terms of severity, how would you classify the contusions or abrasions in this photograph?
They are very small injuries.
Could all the injuries exhibited in State 75 have come from a single blow?
Yes, one impact against concrete, yes.
Let me show you State 73. Was that also a photograph you were provided?
Yes.
And what injuries are depicted in State 73?
Okay, so here again you have to disregard the dried blood that's coming from the laceration to the back of the head. And so you can see very, very faint, again, punctate, small abrasions.
Are any of those abrasions life-threatening?
No.
And how would you classify the abrasions depicted in State 73?
Very insignificant.
Could
Those abrasions depicted in that photograph have come from a single blow.
Single impact, yes.
And why do you say that?
Because the surface area on the side, if you look at my head, and I was to get on the concrete, I could get all those injuries from one impact.
You also mentioned that you viewed video clips of the defendant getting out of a police car and walking through the police station that evening. What did his appearance in that video demonstrate to you regarding his injuries?
He was not incapacitated in any way. He walked on his own power, and he was also conversing with the police officers during this reenactment.
All right. Thank you, Doctor. Judge, that's all I have.
Okay, thank you, Cross.
Yes, thank you, Anna. Good afternoon, ma'am.
Good afternoon.
You got your appointment to your present position because Ms. Corey, the prosecutor in this case, appointed you, correct?
Correct.
Okay, so she's sort of your boss?
Not really, no.
But it was because of her. I mean, she appointed you to this position, right?
She actually sent my name up to the governor. So if you want to call that an appointment, well, then so be it.
Well, why don't we do this? I'm going to read a letter to you. Tell me if you consider this appointment. Pursuant to section 406.15, I hereby appoint... I'll approach and let her review it, maybe. I just have it electronically.
It's okay. I could explain.
Okay, so let me ask the question.
Okay.
Is what I'm looking at a letter signed by Ms. Corey where she says that she appoints you to that position, yes or no?
That was the interim position. I can't say yes or no because I have to explain to you.
Well, I'll tell you what, I'll walk you through it.
One at a time.
I'll walk you through it, okay?
Okay.
There was a yes to that. She appointed you to the interim position?
Yes.
And you had another position as a medical examiner in the state of Florida too, correct?
Yes.
That was with the 5th District?
Yes.
But you were not reappointed to that position by the governor, were you?
I did not seek reappointment.
Okay.
It was
That was
tabled.
because, I'm sorry?
It was tabled. I did not seek reappointment.
And that was because of some of the problems that existed in your administration in that office, was it
Correct.
not? Okay. Yeah, you got the job with Ms. Corey's office, or actually in the same district where she prosecutes, correct?
She's a state, yes, yes.
How much of your work is on behalf of the state attorney's office in that district?
Well, the medical examiner really does not work for the state attorney. We are separate, but most of the time we are called by the state. However, the defense can call us. You could call me on this particular trial, and I would be here for you, just like I'm here for the prosecution.
Fully get that. My question was how much of your work is on behalf of the state attorney's office in Duval County?
All the homicides.
Okay. All the work, right? You only deal with homicides, right?
No, we do suicides, we do traffic accidents, we do drug overdoses, we do natural death where there is no physician to sign the death certificate. So it's other work. Homicides are a very small percentage of our cases.
I'm sorry, then let me clear it up. How much of the work that you do involve crime matters? And I'm presuming in that question that all of your crime matters are dealing with the Duval County State Attorney's Office. So how much of what you do is related to criminal activities?
Okay, so we have a total of 1,165 cases, autopsies.
Okay.
And out of that, we had probably 110 homicides. So that is the proportion.
Okay. And in all of that work, you work with these very prosecutors, correct?
That is correct.
I mean, these are the homicide prosecutors for that division or that office, right?
Well, we have a whole series of state attorneys, yes.
Okay.
But they are in that office.
So they called you to look at this, correct?
Correct.
Did they have you look at anything having to do with Trayvon Martin?
No.
None
well, they sent me the autopsy report, so I saw that, yes.
But you're not here to tell us anything about
No.
Trayvon Martin. You're just talking about George Zimmerman.
That is correct.
And if I get it right, it's your position that's at least consistent that George Zimmerman may have only received as little as 3, did you call, what term did you use, smashing? Or
Sorry?
What, slamming. 3 slamming into cement, correct?
I didn't use the word slamming.
I'm sorry, I thought it was your word.
No, I got that from the reenactment.
What word would you use to describe what happened to the head that you say hit cement?
Impact.
Impact. So it's your position that there are at least 3 impacts between that head and cement.
Yes.
Okay.
Concrete.
concrete. However, and you said it's sort of consistent, so I'm going to walk you through some of that. I'm not going to use pictures right now. Let's just chat a little bit about it, okay? I think you used the suggestion that if you hit yourself in the nose, that it could be all one shot, correct?
One blow, correct.
Okay. You're not certainly just suggesting that it was only one blow, correct?
No, but
Okay.
consistent with.
And you say consistent with to minimize the number of shots that it could possibly be, correct?
Not minimize, but if you gave me another scenario, I could look at that scenario and see if it's consistent.
Let me give you this scenario. He gets hit in the nose like this, just like that, but it does not go up here. So here's the first shot, and here's the second shot. How many is that?
2.
Consistent with that picture?
It could be, yes.
Is it any more consistent or any less consistent than the fact that there was one shot?
I'm sorry, I didn't get that.
I'm sorry. You said earlier that those injuries could be consistent with one shot.
Correct.
And now I think you may have said it could be consistent with 2 shots.
If the way it's depicted like you have depicted, yes.
Well, you don't, just so we're clear, you don't know how Mrs. Zimmerman was hit by Mr. Martin, correct?
Correct.
So you're saying it's consistent with 1, potentially, yes?
Yes.
And it also is consistent with 2, correct?
If the way it was portrayed, yes.
Which you don't know.
Correct.
So could you just say, is it consistent with 2 as well?
It could be, yes.
Okay. And it could be consistent with 1?
Yes.
Right? Okay. And it actually could be consistent with another couple of hits with a palm, or, as you said, another couple of hits with a fist that just didn't leave visible injuries.
Yes.
So you're certainly not telling this jury that Trayvon Martin only hit Mr. Zimmerman in the face 1 time.
I'm just telling you what the injuries are and what it's consistent with.
Okay. Did you notice in those pictures the cuts on Mr. Martin's knuckle on his left hand, both on the ring finger and a slight one on the pinky?
Okay, those are not cuts, those are abrasions. So, because cut suggests sharp force injury, and they are actually where the skin is rubbed off on Trayvon Martin's hand, correct?
That was a yes? You did notice them?
Yes.
Okay. Are those consistent with striking somebody?
Yes.
So we have some injuries, the only injuries, as a matter of fact, besides the gunshot wound, are 2 injuries on his knuckles, correct?
Correct.
Curious, since you've had a chance to look at the autopsy, were there any other injuries on Trayvon Martin at all?
No.
Any bruising injury?
No.
Any laceration injuries?
No.
Any punctate injuries?
No.
So you know for a fact that Trayvon Martin's head or any part of his body was not in contact with cement, correct?
Well, I didn't see any injuries. You can have a contact, but without producing trauma that's visible. So,
As Mr. Zimmerman could have, correct?
correct.
A dozen of them even, right?
Sorry?
A dozen even, correct?
A dozen what?
Other impacts. Well, let's get more specific. We've now talked about the potential of 2, you would even admit, let me ask you this. Is there a possibility that with a swat or a hit or a fingernail or something, that even this abrasion on his nose could have been a 3rd?
Anything is possible.
Well, you're here as an expert,
Yes.
so I want you to give us your opinion. Is that possible based upon your level of knowledge?
Okay, so I will ask this. I know I'm not supposed to ask you questions,
Go
but
ahead.
you know. So then the next issue would be that each of the punctate marks on his head could have been caused by, a fingernail scratch, or I mean that would be the next question posed. And we're looking at the preponderance of the evidence and the opinion rendered thereby. So, we can continue this.
Let's move on. Let's move on.
Yes.
But we'll spend a moment on the nose. So you saw on Mrs. Zimmerman's right side there was a protrusion to his nose, correct?
What does that mean? I don't know.
I'm using the word protrusion. It was the first photograph. Let's go back and see if we can take a quick look at this. You see, you have, we both have one. You have a pointer, correct?
Yes, I do.
You see that spot right there?
That's the abrasion, yes.
No, right below, that little swelling spot right there. Do you see that?
I don't see a spot, but I see swelling, yes.
Swelling, I'm sorry.
Yes.
That swelling to an uninitiated view, actually almost looks like there's a bone over there, doesn't it? But we know it's not, correct?
There is a bone, yes.
Well, but the swelling is not movement of bone, is it? Or is it?
I don't follow that.
Let me just ask you to explain then. What is that swelling on the right side of the nose from?
Okay, so that's trauma, injury.
Okay. And what happens is the body reacts to it by rushing lymph fluid to it and all this other stuff. It sort of tries to take care of the site of injury or trauma.
Yes.
And that recedes pretty quickly, doesn't it?
Oh, it depends on the extent of trauma, yes.
Well, and we know in this case, you acknowledge the trauma and the swelling there, right?
Yes.
And you notice in the pictures after it that the swelling has receded, correct?
Yes.
So it does recede after a few hours?
Depending on the severity. Here it was not severe, so the swelling rapidly declined.
And you know that there was blood coming out of the nose as he was standing up, correct?
Correct.
Where do you think that was bleeding from?
From inside his nose.
And where would that go if he's laying on his back?
Where would what go? I'm sorry.
The blood?
Well, it depends. If you are alive, you would, if it went back in your throat, you would cough it out.
Or swallow it?
Well, I don't know.
Well, I mean, it's going back down your throat, isn't it?
Yeah, you'd cough it out. I don't know if you would swallow it, but maybe that's a good suggestion.
Okay. So we have the nose injury, one. We have the potential of the injury up here that you identified could be a second shot, correct?
It's possible, yes.
Well, I mean, if I showed you a picture, let's just say that we did, in fact, have a video. And the video showed a smash to the head, to the nose here, and then sort of an overhand. Let's say that it was an overhand shot. And you had a video, or let's say an eyewitness, who saw an overhand shot. Would that be consistent, the overhand shot, with that injury up there?
The small bruise?
Yeah, right up there.
It's possible, yeah.
Well, is it consistent?
It could be.
Okay. On the back here, you testified that you believe that all this was created or consistent to have been created with just one strike on the concrete or cement?
Okay, so all this, I don't follow that. I see 2 lacerations and a small bruise.
Okay, you see this laceration?
Yeah,
you
but
see this laceration.
Okay, so, it's being actually camouflaged by the dried blood and the dripping of the blood, but once cleaned, the nurse that examined him said one was 0.5 centimeters and the other one was 2.0 centimeters, which is very small. And so, after it's cleaned and you look at the photographs, you don't see what your suggestion may be that there are a whole series of injuries back there.
All right, well, I'm just going to ask a couple of questions about all this. You said, I think, in direct examination that this is consistent with one strike upon cement, correct?
Concrete, correct.
Concrete. Now, you're not suggesting to some reasonable degree of medical certainty that there was only one strike here, correct?
No.
So this could, according to where this was, let's identify a term. I'm going to use the term crown, and we know the crown of the head normally is up here.
Correct.
But I'm going to use crown in a different term for the next few questions, okay? And that means the point that hits the cement. Can we use that term for just a couple of questions? Do you know what I mean by that?
Do I do what? Sorry.
Rather than the crown, which would be the first thing to hit the ceiling if you stand straight up, I'm going to say that, let's just say that this is where the impact on the cement is, okay?
Okay.
Now, the head could impact just there, correct? And just hit there, right?
Well, if the impact is on the side.
Absolutely. Because we don't actually know what part of his head contacted the cement, do we?
We know that there are 2 injuries that resulted from the impact.
Right.
That's a given, right?
And they could be separate, right?
Except that it's in close proximity, yes.
Right. So I could hit a knuckle right there, or I could hit 2 knuckles at a time, correct? So it's according to how it happens, right? What the physics is of how it happens?
I'm not very good in physics, but we're not talking about knuckles, we are talking about one surface area. So I can explain just simply, I don't know about what the physics of this injury is.
Then let's get away from physics and talk this way. Let's just say that he was hit where, see this line right here? See that line? Do you see me making a line?
You mean the area?
No. The line I'm making with the laser.
Okay.
Okay. Let's just say that only that on this side came in contact with the cement. Is that possible?
Oh, yes.
Okay.
It's possible.
And if that were true, that only the point on this side came in contact with the cement, that only that injury would occur, or could occur that way, correct?
It's possible.
And now, if we look at the other side, the same line, that side, let's just say that only this side of the skull was in contact with the cement, then that injury would happen, correct?
That's possible too.
2 separate injuries, correct?
It's possible, yes.
You're not suggesting it's any more likely 1 or 2, are you?
So we are doing the preponderance of the evidence, and the preponderance would suggest that one impact is more plausible than the way the head is shaped to have 2 separate impacts. But if you say that was something that was eyewitnessed, then yes.
Well, what if somebody put their hand, let's say, on the side of a skull and smashed this way? Would that?
Fact's not in evidence.
I'm sorry, Your Honor? I didn't hear the objection.
The fact's not in evidence, sustained.
Well, let's just say that you have evidence that there is a fist being hit down on one side of the head. Would you agree that the opposite side of the head would be forced downward?
It could.
If okay, so it could, right?
It could.
All right. And then that would cause an injury just on one side of the skull, correct?
It could.
And you see this bruising right here, do you not? See that swelling?
No, that's the shape of his head, I think.
So in your opinion, you've come to a medical conclusion that that crowning over there is natural?
Yes, that is the parietal area of the scalp, yes.
I'm curious why it doesn't seem to show itself as protruded on this side.
Sometimes the shapes of heads are different, we're not all symmetrical. And if you look, there is no discoloration there. So that may be an anatomic variation.
So right here, do you see any bruising or any discoloration at all in that photograph?
Okay, I don't see bruising, but I see small, very tiny punctate marks. And the other thing is, the photograph you're looking at, the hair is so short that if there was something there, we would be able to see it really well. And I have to strain to look and to see what you are suggesting. So I can't answer that question.
I just want to be clear because the jury will have not even these photographs, but they will have much better photographs to view and to study. But as I do that, I want to point out to you, to see if we can focus you, is it your testimony that this coloring here, this darkening in this way, is a natural occurrence on his skull and not evidence of a bruising? Yes or no?
I don't see a bruise there, but I did see, because I also have very good photographs, which you can see clearer, there are very fine punctate abrasions.
Okay. Let's speak a moment for what you do see then, the punctate bruising.
Not bruising, abrasions.
Punctate abrasions, I'm sorry. Is that the abrasions that you see over here?
Well, again, the photograph is so poor that, I have to look at my own photographs.
Then let's take a moment.
Okay.
Can I have some lights, Your Honor? And I'm going to leave this up because it would be easiest for the jury, but let's coordinate, if we might, doctor, the photographs you did look at and these photographs. May I approach the witness?
Yes,
Are you reviewing the photographs that you had?
Okay, so I will show you my pictures that I have. I printed them from the computer. So this is the one side. this is the, I think the photograph that you're showing, and you can see very fine little abrasions there.
Well, let's identify that you're now looking at a copy of what is State's Exhibit 73, and I think we're going to have to do this a bit more formal. So if I have a moment, Your Honor, I'm just going to have to get the actual 8x10s out of evidence. What I'm going to try and do, Doctor, is to identify your photographs and connect them to the exhibits in. Did you get an entire picture packet from the State Attorney's Office to review?
No, I got a disc, and I printed out some of them because it was taking me so long on the computer, so I just printed a few of them.
Then we'll do it this way in case you don't have them all. May I examine her from this location because I've got exhibits that we do not have on.
Is the jury able to see in here? Yes, you may do so.
Let me show you what's in as State's Exhibit 69. Your Honor, these are in already, so I'm just going to identify them for the jury and have her testify from it. And let me ask you if you can look, first of all, let's identify, this is in fact State's Exhibit 69?
Yes.
Okay.
Yes.
You want to hold it for a second? Thank you. And I'm going to question you about that if you look at the photograph. Is it your testimony that in Exhibit 69 there is no bruising above Mr. Zimmerman's left ear?
I just see the punctate abrasions. I don't see bruising. And there are some marks on the head which are nevi, which are moles, brown moles. So you are seeing that also like there and there.
So, to point out, 2 inches above his left ear, this area of lightening and darkening you do not perceive as swelling?
No, I don't think that's swelling. I just think that's the shape of the head. But it's a very, very funny angle. And so there's distortion in that photograph, and I cannot tell you that that's bruising. I'm sorry.
Okay. And similar in States 57, so we're clear for the jury. In 57, sort of a back view, I asked you to focus first at the area we just looked at, which is about 2 inches above Mrs. Zimmerman's left ear. Are you suggesting that, again, that is not any type of swelling or bruising, but rather just the natural contour of his head?
Okay, so if you are suggesting that that's a swelling, then the bruise should be so marked that I should not have trouble looking and identifying that as a bruise. So I can't comment on that.
Is that a yes or a no? Do you say that that is bruising or not?
No,
just above.
No, I can't see the bruise there. If that's what this part is what you're talking about, yeah, I can't say that.
let me show you State's Exhibit 70 that's in evidence, which is a picture of the right side of Mr. Zimmerman's scalp, correct?
Correct.
And pointing your attention to the laceration, bruising, cut, use your term, not mine, just in the middle of that picture.
Yes, he has a bruise on the right side, plus he has the punctate abrasions.
Okay.
Yes.
The bruise on the right side, how do you think that was, how did that occur?
Impact against concrete could give you that, and the other abrasions.
Now on number 70, let's look further back about 2 inches towards the back of his skull and tell me what you see there.
Okay. Are you referring to the small?
Yes, I am.
Okay, that is a small bruise. It's pink, discolored.
And is it your testimony to, well, how did that occur?
Impact could give you that.
And could that have been a different impact?
It's possible, yes.
It is possible,
it's
correct?
consistent, yes.
Matter of fact, how much of a distance do you think there are between those 2 points of impact?
Well, I think it's not just the distance, but also one has to look at the curvature of the head when you are, and when I'm giving you an opinion, I'm not only looking at the distance between the two contusions, but I'm also looking at the contour of the head.
That's what I was curious about, so let's talk about that. The contour of the head is somewhat sphere-like, is it not?
Oval, yes.
Oval. So if you have 2 points on a sphere or an oval, correct?
Correct.
It's convex, is it not, the skull?
Yes.
So if you have 2 points 2 inches apart, why is it not a continuous bruise or a scarring all the way across? Why would you have 2 separate ones?
Okay, so it's not scarring. Scarring is a different terminology.
I apologize for the misuse of the term. Why is it not one long, if it came from one contact, why is there not one long injury?
Okay, because the force applied to one area because of the contour may not be equivalent to the force in the other area, and so in one site the force may be sufficient to cause a contusion, but it's not. We're not like computers. It's not. You do something and you expect this result. We are dealing with a different configuration of the head, so I don't think that follows. It's a nice thing to be able to say, but I can't say that.
Okay. Certainly it could have been 2 separate injuries, correct?
It's possible, yes.
Okay. And looking at States 69, I want you to pay some attention to what seems to be a view of the Mrs. Zimmerman's skull, correct?
Scalp, yes.
Scalp. That's right. His skull will be underneath, right?
Correct.
And I want you to pay attention to the top of the picture and see if you can tell us what you believe that protrusion to be. My term, not yours.
Okay, so on the other side, we are actually looking at a photograph of the left side of the head and the top of the head, and we actually are getting a view on the right side of that bruise that we talked about. So that's the same bruise.
Do you see the swelling is my question?
Yes.
Okay. So there's swelling, and you're suggesting, I would like you to be clear about this for the jury's consideration, that in exhibit number 69, you do acknowledge swelling that seems to be to the right side of the midline of the scalp, correct?
Correct. But you got the bruise, which, if you want to say, well, this is a swelling, but there is no bruising there. And if the swelling was so severe that you are looking at on the left side, then we would have a significant bruise, and we don't see that. Whereas there, it's a small bruise, but you can see the swelling. So you can't separate one from the other. So it's together.
Look at number 70, which we've talked about already, and tell the jury which bruise you believe that swelling is connected to.
I think it's that one. Because
I just want to be clear, you're thinking to the one that is behind the ear. You pointed to the one that is 2 inches or so behind the line of the ear.
I think because that's such a distorted photograph because we are able to see very well the right side. So why are we looking at a photograph of the left side and trying to draw that conclusion? I think that's extremely unscientific.
And I apologize for that,
No,
but I
it's
just
not
want to
your
be
fault.
clear about one thing. It is your testimony here today that the swelling that's on the 69 on the right side of the midline of the scalp, that is the bruising that is the same bruising as exists with what you've identified now as the bruising behind the ear line on States 70, correct?
It could be, but like I said, it's very difficult for me to, to give an opinion on the photograph, which is so distorted.
Got it. Could it be a completely separate bruise?
Which one is
This
that?
one, the one on 69.
Well, if it was, why are we not able to see it from the right side?
Let's take a look at 71 then,
Okay.
and see what you see on that photograph.
Okay, so this is again the punctate abrasions that I talked about, and that is the bruise that we have to overlap. I think that's the
And let me
photo.
show you just at the very top of the crown of the head there, almost out of the top of the picture. Is that not the bruise that we see, or the swelling that we see on 69?
I find it difficult when half the photograph is cut to give an opinion. I would like to see what the injury is before I tell you that that's the injury. So why are we looking at distortion and half photographs when we have the full side to be able to look at and to render an opinion?
Well, I certainly only want to do and have you give us as good an opinion as you can. Do you have a photograph that better shows the injuries that we've now seen by looking at 69, which shows the swelling that seems apparent?
No, I have the same, but I have just copies.
Okay, but that doesn't show the swelling, does it?
They're the same photographs, so how can they not show? Okay, so they are the same photographs, so how can it be different?
I'm asking you, as you're here today, to tell me what picture you have of the right side of his scalp that shows or doesn't show the swelling that was apparent in State's Exhibit 69.
Okay, so I have the same photographs you have, except mine is, like I said, copies. So this is the photograph that you are describing?
I'm trying to find the one that's in evidence for that, if I might have a moment, Your Honor. Let me ask you to compare, if you would, the picture that you were just showing with State's Exhibit, I'm sorry, let me identify it, 70. Do you have that one?
I'm looking. Oh, no, I don't.
We have this back here. Thank you. So, the least number of contacts between scalp and cement were 3, correct?
Correct.
And as many as how many?
That's a scenario that you posed, so you would know how many.
Well, if you were to look at this from a medical perspective and try and come up with not the minimum number, but the maximum number, give us your opinion.
I told you 3?
That's the minimum, correct?
Correct.
My question is, tell us, in your professional opinion, how many it could have been as a maximum.
I don't know.
Why not?
Because you were presenting the scenario about various possibilities, so
Sure.
you have to tell me, and I will tell you yes or no.
Well, as I as I said to you, there could be a possibility that those two bruises were two different ones, correct?
On the head, yes.
Two bruises on the right side of the scalp.
Correct.
Okay, so I want you to include that. We also talked about the possibility that the two lacerations could be two different hits, correct?
Correct.
So I want you to include that. What other, and we talked about the nose and the forehead being two separate ones, correct?
Correct.
Okay, so keep going. How many other of those bruises could have occurred? Let's talk about the left side of the scalp. It has been your testimony that it is consistent with just the least amount of one strike on the cement could have caused everything on the left side, correct?
Correct.
How many could it have been more than that?
I don't know. You have to give me a scenario and we will say consistent or not.
Okay, he got hit 6 times on the left side of the skull. Consistent?
No.
Why not?
Because the injuries are so minor and they are patterned to some extent. So that would be beyond the realm, I think, of possibility.
4 hits on the left?
Well, if somebody is an eyewitness and says 4 times that this injury occurred, then of course that's the best estimate. So, you know.
Okay, so let's talk about 4 on the left side. You agree that would be consistent with the medical evidence, correct?
If it was witnessed, yes. No. But you can't just say 4 times and you're not seeing the injuries to match the 4 impacts slamming.
Listen to my question.
Okay.
Is there any medical evidence that would exclude the possibility that skull was hit on the left side 4 times?
That's not my opinion, but it could be. It's possible.
Okay. Nothing to exclude.
Nothing, sorry?
Nothing to exclude that as a possibility.
It's possible.
Okay. Now on the right side, the side where we see the 2 separate bruisings, we talked about that, right?
Yes.
And we also see the punctate bruising in front.
Abrasions.
Abrasions.
Correct.
Anything that would medically exclude that the right side was hit 4 times?
It's possible.
Okay. We see 2 of the bruises, right? And they could be separate, right?
Possible.
Then we see the punctate abrasions. That could be another one, right?
It's possible.
Then we see the swelling that you say may be connected with one of the bruises, but that could be separate, correct?
I don't think so, because underlying the bruise you have the swelling. It's so impossible to get a bruise and a swelling and say, well, that was 2 different sites. Now, the swelling is separate from the bruise, yes, but they are one injury.
Okay. Presuming that the bruising on States Exhibit 69 and 70, that the bruising that we see matches up in the jury's mind with that point of swelling, correct? You're making the premise.
It does.
Okay. In your opinion?
Well, you can see it.
Okay. And the jury will, of course, make that determination, right?
Correct.
Okay. And then there could be how many maximum times could the back of the head have been hit on the cement?
Well, to me, it was consistent with 1, but you suggested by turning the head in different ways, it could be 2. It's possible.
3 or 4?
With no injury, yes. If the head is in contact, producing no injury, yes.
How about the swelling below the lacerations? Did you notice that?
The contusion.
Below, right.
The contusion, yes.
Could that have been a separate injury?
No, it's possible.
Well, if the head was hit so that just the crown hit the cement 1 time, let's say his head just snapped back and it hit here, that could have caused one of the lacerations, correct?
Yes, but it's so close to each other. That's the proximity that really kind of makes it possible.
Okay, I appreciate that. So if the head was tilted one way and then smacked back so that this was the crowning point, that would be 1 laceration injury, correct?
It's possible.
And then if the head was this way another laceration injury, correct?
That's possible.
And then if I was able to resist one of the tossbacks of my head, I can actually keep the crown higher, and that back bruising that you just identified could have occurred, right?
It's unusual because, you're talking about a flat surface. So the head will have to be really contorted to be able to give you all those injuries from different impacts.
Change it now that it's not the cement, okay? Change it that it's here. Change it that what was hit, that the bruise on the bottom wasn't flat, that it was against the side. Would that cause the bruising down here without the lacerations?
The side of what?
Side of the cement. You know that it was a cement sidewalk, correct?
Yes.
And you know that they were at the very edge of it, correct?
Yes.
So you know that there is, in fact, an edge of cement, correct?
It's possible.
I'm sorry?
The injury is possible, like you are suggesting. Yes.
Well, here's the cement, and we've been talking, discussing as though all the injuries are on the flat surface, right?
Correct.
So let's introduce now that there could have been some injuries here.
Your Honor, object to that as facts, not in evidence.
Hypothetical with an expert overruled.
It's possible.
Okay. So the possibility is that the head being hit against the cement could easily, the two lacerations above may not have ever impacted again when the bottom bruising occurred, right?
That's possible.
Okay. Mr. Guy focused you on life-threatening injuries, right?
Correct.
Did they suggest to you in your testimony that this has anything to do with life-threatening injuries?
I'm sorry, I didn't get that. What is
Did the state attorney's office, when they prepped you for your testimony here today, suggest to you that life-threatening injuries was an element of anything having to do with this case?
No.
Okay. You understand that the extent of injuries are not significant in this case, do you not?
I'm sorry, I didn't get that.
Okay. You understand that the extent of any injuries that Mr. Zimmerman incurred in this attack have nothing to do with the case itself, correct?
I object to that as calling for a legal conclusion.
Rephrase your question, please.
I will. Were you prepared for the examination to identify whether or not you could testify that there were life-threatening injuries or not?
No.
Okay. None of these injuries that you identified as they turned out were in fact life-threatening, were they?
Correct.
What about the next injury?
The what, sorry?
The next injury.
What is that?
The next injury he would have sustained.
I'm sorry, I didn't get that.
Could the injury that he didn't have to survive, could that have been life-threatening?
Object to that as calling for speculation.
Sustained.
I might just have a moment, Your Honor. Thank you, nothing further.
Thank you. Any
Just
redirect?
briefly, thank you, yes. Dr. Rao, who was it that appointed you chief medical examiner for District 4?
The governor.
And are you testifying here today because Ms. Corey wrote a letter on your behalf to the governor some years ago?
No.
Are you slanting your testimony anyway today because Ms. Corey wrote a letter on your behalf to the governor some years ago?
Absolutely not.
All right. You were shown some photographs by defense counsel. Were you provided with all of those photographs prior to trial on the disc that you referred to?
Yes.
In fact, I think you referred to 36 photographs of the defendant?
Yes.
Did that also include photographs of his hands?
Yes.
Would you expect someone who was
undergoing a severe attack to try to defend themselves?
Object, Your Honor, outside of scope and also speculation.
Sustained on both grounds.
You were asked about a scenario where the defendant may have hit his head on the edge of concrete when you watched the defendant's walkthrough or recreation. Did he describe his head getting hit on the edge of concrete?
No.
Judge, thank you. That's all I have.
Thank you. May Dr. Ryle be excused?
She may.
Thank you very much. You are excused. Call your next witness, please.
Mayor, the next witness is available, but could counsel approach very briefly?
Yes. Have a 15-minute recess at this time. If you'll put your notepads face down on the chair and follow Deputy Jarvis back into the jury room. Please be seated. Court will be in recess for 15 minutes. Please be seated.
We're going to have the matters addressed before the jury's brought in. No need to be the bench, correct?
I don't know what it is you want to address.
Just an objection and request for a proffer of some testimony I think the state is about to present concerning some school records or school information or coursework taken by my client some year or two before this event. And just a general relevancy objection, I'd ask it to be proffered, and then if there's any relevance whatsoever, that it be outweighed by its prejudice. And I just have concerns about putting in portions of a school book that he may have read in a course that he had 2 years ago, and that's my objection. So I would ask it to be proffered and its relevancy be shown.
Okay, response?
Yes, Your Honor. Actually, there are 4 different records, 4 different witnesses. The first is, generally speaking, a transcript of the defendant's coursework towards his degree in criminal justice at Seminole State College, and that shows that he took 149 hours, I believe, altogether towards that degree, including a number of classes over a number of years. Was on schedule to graduate, although hadn't yet. So that is record number 1. Record number 2 is one of the courses that he took, specifically taught by Professor Alexis Carter, and some of the homework assignments that he performed for that class. For the record, that course was titled Criminal Law and Procedure. It involved, as Professor Carter will indicate, discussions extensively of a number of Florida laws, including self-defense and the stand your ground law. Record number 3 is a application to be a police officer for Prince William County in Virginia, and simply the application and the fact that he was not accepted for that position. That is it. And then the 4th is a record of a Sanford Police Department application to ride along with police officers. Those are the 4 records. As I understand it, the objection is relevance as to each of them. Obviously, they all go to support
a number of things, not the least of which is the state's underlying theory that this defendant had such an interest in law enforcement and law enforcement work that this is what he is, this is the position and the frame of mind that he is operating from at the time. In other words, this is what he wants to do. He wants to catch people. In fact, one of his homework assignments, he specifically mentions that. We believe that his chosen major, which actually has been mentioned in other evidence already, that he was seeking a criminal justice, is relevant to show that he has the education and the ability and the understanding, and has at least the background to be able to adequately discuss when he is confronted with police, both understand what it is that they might be trying to do and also what it is that he might say in order to address the situation in the light most favorable to him, legally speaking. I think as far as his knowledge of the law, that certainly would be relevant to his statements and his state of mind while making them, particularly as we just heard him tell Sean Hannity on national television that before this case he'd never heard of the stand your ground law. That would be directly contrary to one of his professors. And the other two records, the application to in fact be a police officer, as well as to ride along locally, I think would be relevant again for the same reasons. This is a ongoing pattern of behavior, and it shows that this defendant has had that interest for some considering time, and that this is very important to him, that he be able to act and potentially become like a police officer. And it is the state's position that one of our arguments in this case is that that's what he was actually trying to do at the time of the encounter for which he's on trial in this case.
Okay, response?
Well, the response, Your Honor, is that it simply isn't relevant. What they're trying to do is use a transcript, for number one, trying to use a transcript that he did, so he didn't even complete the degree, but to the extent that they're going to try and put before this jury that he went to community college seeking a legal studies degree is of no relevance to them. This event is supposed to have occurred within 7 or 8 minutes, exactly what happened that day. We have taken pains not to get into Trayvon Martin's school records and his past because we know that they carry a level of protection that they're supposed to protect. In this case, what they're trying to say is that because he went to college, because he went to high school, because he went to first grade, maybe even because he had a civics class, that is going to be able to get before this jury so they can focus not on evidence, not on hard and fast evidence that they have, but on some theory that he acted in a way after going through what he went through that night that he knew to say to the cops something that he said it while the evidence supports it. All I'm saying to you is that if it's relevant to an issue, a material issue, then let him show what that relevance is. The idea of just doing a witch hunt, if you can, or at least a fishing expedition, to try and argue to this jury at some point that he went to college and even that he wanted to drive along with a cop somehow is a negative thing, somehow suggests that it's bad that he wanted to go to college. I don't see any relevance, and if there is any minor relevance, rather than just a fishing expedition, it's certainly outweighed because
I don't understand when you say it's a fishing expedition from the exhibits that they're intending to introduce.
Okay, the fishing expedition part of it is what they're trying to say. They're trying to come up with some theory. They don't get to just say, Judge, it's our theory that he's a bad guy because he went to college, but in effect, that's what they're doing. Their theory is not supported, at least yet, and they're a week and a half into their case, hasn't been supported by hard, fast evidence suggesting the anger and the animosity they want to try and get.
I don't think what they're trying to introduce is, for that purpose, from what I heard Mr. Manti say, is for the Mr. Zimmerman's knowledge of criminal justice and techniques of investigation techniques, interview techniques. He did say on the interview that was played from the state's exhibit number 180, the interview with the Hannity show, when asked the question if he knew about stand your ground law, and he said no, he did not. So
that's correct.
That's one of the things. It's the state's saying that it's not a fishing expedition, it's to show that the defendant had knowledge through course review as to police techniques for interviewing. I don't know what the course information is going to indicate, what was taught.
Well, the reason why I call it a fishing expedition is then I don't see, where does it end? And that's why I'm suggesting it's a fishing expedition. Do now everyone who's gone to a 6th grade civics lesson?
That's not what they're seeking to introduce or trying to introduce courses that Mr. Zimmerman took in criminal justice or towards a criminology degree. It's not like they're trying to introduce that he took humanity classes or he took a 6th grade geography class. They're being specific. I haven't seen the exhibit. Presumably you have.
I'm not looking, sorry. I'm looking at it, I don't see anything that says standing ground was the only thing he said he didn't have, but I'd have to look at it and see.
Well, there's 4 exhibits up there if you want to take your time to look at them.
As I said, Professor Carter will describe in detail the standard ground portion of that coursework. It's not referenced by name in the book. That's why he's here live. But that's sort of just an aside. I want to make sure that point was clear if we're going to argue about it.
Okay.
We're going to go, I guess, go back and forth a little bit.
Well, I would, again, I have not seen any of the proposed exhibits. I have no idea what you all are talking about in regards to each of them. If somebody would like to hand them to me, I'll review them.
Let me see the police out. In order, Your Honor, 209, which... Sure. 209, which is the coursework towards the degree, including a certificate from Professor Carter as to the specific class in question in which he awarded the defendant an A.
Well, these records are his college record that shows all other classes and what those grades are. I would agree that that's not relevant, and attached are grade change and academic record update form.
That is the record from Professor Carter awarding the grade for the particular class.
Okay, course title, criminal litigation.
Yes, Your Honor.
Spring 2010. There's a diploma certificates application.
Which I believe shows the proposed graduation date of late 2012, 2013.
Is that the only class that, the criminal litigation, the others, there's a criminal investigation, I see?
Correct. The criminal investigation is the subject matter of the professor about which we had a discussion this morning, Professor Pleasance, and I have an update on that situation when we get to that point as well.
I don't know that all of these records would be relevant because they show other course of study, but as far as the criminal litigation and criminal investigation, they will be. So you need to redact these records to comply with that. What's the next exhibit?
Your Honor, the next exhibit is a composite of 210, and I don't know if this one is the course book material as well as the homework from the criminal litigation class. Mr. Omerta at one point indicated that he wanted the entire course book entered, and so I have that available. I'm not sure whether that's still the desire. The other part is just the section relating to self-defense.
Now, is there a live witness who's going to testify as to these exhibits?
Yes, Your Honor. Professor Carter is here. These all have been.
Okay, I guess there's two parts of Exhibit 210. The first one are different homework assignments.
Yes, from the course.
And a final project paper.
And that's continue to be heard on the objection that I was outlining before.
On this Exhibit 210, yes.
Actually, on all of them. I don't think the state can create evidence and then, for the sole purpose of impeaching it. They introduced Sean Hannity. They left in that portion about standing ground, and now they're trying to bring in additional evidence to try to impeach Mrs. Zimmerman on what they put into evidence. So I think, and I don't have the case law right here, but I'd be glad to present it to you, that they can't create evidence. They can't ask a question the way they did.
They didn't ask the question.
Well, they presented the evidence.
Okay.
And they could easily have redacted that had they had the concern to. They left it in solely for the purposes of bringing in suggested impeachment to say that he did say something or know something when he didn't, when he said he didn't. So they can't create their mild problem by putting in evidence solely so they can impeach it. Your Honor, I think that is unfair. It's inappropriate, and they shouldn't now be able to come in and impeachment. So that's sort of as an aside to what they're attempting to do.
Wouldn't that be the same as declaring a witness as a hostile witness?
Well, I think what they're doing is they can't open their own door, Your Honor. I think rather than impeaching as a hostile, what they cannot do is, as you sort of suggested last week in the trial, you can't open the door a little bit yourself so that you can push through it. And that's what they're attempting to do by leaving that in to an otherwise redacted statement, just as an attempt, a foothold, if you would, to get in evidence that now might suggest, not in the book, because the book says nothing about standing ground, but that some professor may come in, acknowledge that George Rosa was not even in class that day, and talked about standing ground. I presume that's what they're going to have him testify to. And they can't simply create their own impeachment evidence, which is what they're doing with that particular attempt.
Well, I'm going to have to give you time to look at some case law on that, because I don't know at this point in time that I agree with that.
If I may, the state's position would be, although it is impermissible to call any witness for the sole purpose of impeaching them, that is certainly not the reason that exhibit was admitted, and I would point out that it was admitted upon stipulation of both parties.
Right, and the court even read the instruction to the jury that portions have been redacted. So that creates a whole nother issue.
And as to the school records themselves, even, I understand the court's ruling as to some of it, but even as to the other ones, again, I don't think it's appropriate for the state to focus this jury on evidence of my client.
That's their case that they're trying to present to the jury. That's their theory of the case. And they're allowed to present evidence on their theory of the case, just as the defense is allowed to cross-examine their witness on their theory of their witnesses on your theory of the case.
My understanding is that there at least there needs to be some connection.
Okay.
That they can't just allege that he took a class in junior college a couple of years prior, and therefore then ask the jury to presume something without some direct evidence. And to date, there has been no direct evidence connecting any of that together.
Well, your cross-examination of the different witnesses regarding the incidents that occurred on that night gave an indication that the jury could infer that your client did not have any information about what self-defense means or is, or an understanding of the criminal justice system. So I think that that's before the jury based upon that. So if it's the theory of the state's case that Mr. Zimmerman had that information, or at least understood the process, I think they're entitled to bring that forward. If you would like a few moments to get some case law on that, I'll recess for about a half hour, and you have people there helping you. You can go ahead and try to find the case law.
As to the request for the proffer, then, can I at least request that the state proffer that they're going to be able to connect up? As an example, I mentioned a moment ago, if they're going to suggest that my client knew about standing ground, would they not need to at least present evidence from their witness that my client was present during some coursework that was given? If not, then it's pure supposition. I don't think it would be then, the relevance is not bridged That's what I was talking about a moment ago, maybe not artfully, but if they can't connect the dots at all, they can't just allow this jury to sort of guess as to what it means. So if standing your ground is going to be an issue, and they now want to show he was there for standing your ground, shouldn't they at least show he was in class? And I asked for that properly.
So I'm going to say one thing about that is we've now moved again, as so often has happened here, from the original objection to 4 different points removed from the original objection. If we're now asking for a proffer about whether or not the defendant was present, I think it misses the point. The point is he had access to this information in the book. He had access to the information from the class. And
I haven't seen the book.
And that makes it, you have the chapter in front of you, which is a portion of that exhibit.
The self-defense chapter
Yes, Your
7
Honor.
is the portion?
Yes, Your Honor.
That came from the book?
Yes, it did. And the relevance of all of this, again, taken together, is that the defendant did have this information or access to this information. Whether he wishes to claim that he wasn't there that day or whether on cross-examination they wish to ask the professor whether or not he could guarantee he was there that day, that goes to the weight of the evidence, not whether or not it's admissible in the first place. It's relevant evidence. As far as the idea that it's more prejudicial than it is probative, it's odd to first say this is good things and then argue that it is so prejudicial that it is unfairly prejudicial to the point that any relevance it has is outweighed. Those two arguments are completely inconsistent with one another.
Let me try and make them consistent because
Okay, no, let me go ahead and do this because we could go back and forth on this and all the time, and I'd rather give you the opportunity to go back and do a little bit of research. We'll be in recess for 30 minutes, and let me see what case law can be provided. The other 2 exhibits before we recess on this are...
One is an application to be a police officer.
And what is the date of that application?
That is, it was July 8th, 2009 was when that was resolved.
Okay, and the other one is an application to ride along. What is the date of that?
3/15/2010.
Okay, I will consider all of those. We'll be recessed for half an hour. Thank you. Please be seated. Do we have some case law, or we need more time, or where are we in that regard? And I guess...
I think both, but maybe we could address some of the specific objections to the pieces of evidence, have you rule on those, then what's left, I might ask for some time for some case law.
Well, I was wondering if that is the case and we're going to spend the time doing this. Do you have any other witnesses that are not on this issue that are here available to testify? Okay.
Yes,
Why don't we do that? Why don't we go on to the next witness, and we can take this up after the court is over and take it up at 8:30 again in the morning. So we can do what we can after this unrelated witness testifies.
Yes, ma'am.
And then afford everybody that opportunity.
I'm amenable to that, Your Honor. I will point out, just so the court's aware, 2 of the witnesses are actually flown in from out of state, so we will have to make that arrangement, but I'll get that done. And
Okay,
we'll be
well,
prepared to-
you know, this is the first time the court is hearing the argument about this.
Yes, Your
The
Honor.
parties have had these exhibits known to each side for I don't know how long. I didn't know until just now we were going to have that argument, and if parties are not prepared to continue on with the argument, I'm going to give them a little time to do so.
The state's prepared, Your Honor, but that's fine. We can wait.
Okay, let's go ahead and bring the next witness. Do you need somebody to get that witness?
Yeah, Judge, I think she's on the second floor. We're having her brought up right now.
Okay, thank you. With that in mind, is there anything else that we need to take up before we'll have the jury come in?
No, Your Honor.
Let me know.
I would ask the court's permission so I can inform the other witnesses that we won't need them till tomorrow and that
Yes.
they'll be spending an extra night.
Okay, thank you. Just when we know the witness is outside.
Judge, just for planning purposes, we believe the only witness we have available other than those is very short, we believe so, but I guess it's getting close to 5 o'clock anyway, so I think we're all right. Just want to
Okay.
alert the court.
Thank you.
We do have depositions set for this evening as well, starting at 5:30. So.
Okay. Witness is here. Let's go ahead and bring the jury in. Please be seated. Mr. Guy, call your next witness.
Judge Kristen Benson, please.
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Good afternoon, ma'am. If you'd please tell the members of the jury your name.
Kristen Benson.
Ms. Benson, how are you employed?
I work as a latent print analyst for the Seminole County Sheriff's Office.
How long with the Seminole County Sheriff's Office?
I've been with the agency a total of 8 years.
And how long in the area of latent print examination?
Just under 3 years.
Can you tell the members of the jury briefly what your duties are as a latent print examiner?
I examine items of evidence for the presence of latent prints. I also perform comparisons of latent prints to known standards, and I issue reports with my findings.
And if you could summarize, please, the training education that you've had to prepare you for your duties as a latent print examiner.
I have a Bachelor of Science degree in Business Management. I also successfully completed both the latent print technician and analyst training programs at the Seminole County Sheriff's Office. I also received approximately 300 hours of additional training from the Federal Bureau of Investigation, the Florida Division of the International Association for Identification, among other agencies as well.
Have you ever been tendered as an expert in the courts of the state of Florida in the areas of latent print identification and/or latent print comparison?
Yes.
How many times?
7.
At this time I would tender Ms. Benson as an expert in the field of latent print identification and fingerprint comparison.
She will be allowed to testify in that area.
Explain that, if you would, please, for the members of the jury. What is a latent print? What do you mean by that?
A latent print is the unintentional recording of your fingerprints or palm prints. When you touch a surface or an item, residue such as perspiration or body oils that may be present on your hands can then transfer the ridge detail that's found in your fingerprints onto a surface, leaving behind a latent print.
And what is meant by the expression a latent print of value?
A latent print of value means that there's a sufficient amount of information in that latent and the ridge detail in order to either identify a person or eliminate a person as being the source of that latent print.
Is a latent print of value then one that is suitable for comparison?
Yes.
How can a latent print not be of value or be of no value?
It may lack clarity. It may lack information in the ridge detail. It also may be heavily distorted.
If a person touches a surface, and I'll use my example, my thumb on that surface, is there any guarantee that I'll leave a latent print of value?
No.
Why not?
First of all, there has to be enough residue on the hands present to transfer onto the surface. Another reason might be is the surface of the item that you're touching or the object needs to be conducive to receiving a latent print. Generally, heavily textured or rough surfaces are less likely to receive a latent print than, say, a smooth surface would be.
Can latent prints be destroyed if they are deposited?
Yes.
How is that?
Excessive handling of a surface or the object that has suspected latent prints on it can wipe away, damage, or destroy latent prints. Also, environmental conditions such as rain or heavy humidity can damage or even destroy latent prints.
And in your field, what is meant by a latent print card?
A latent print card generally is a white card that's used to preserve latent print evidence on.
And how are those used in your work?
Generally, we receive latent print cards to examine for the presence of latent prints.
What is a known ink print?
A known inked print is an intentional recording of your fingerprints or palm prints for the purpose of identification.
And if you have a latent print of value and a known ink print, explain for the jury how you go about comparing those two to determine whether or not they were left by the same individual.
Once I've determined that there's a latent print of value, I'm then going to do a side-by-side comparison with the known inked print. I'm going to look for similarities and differences. I'm going to look for things that may be in agreement or not in agreement. And after a thorough examination and comparison is completed, I'm then going to determine that it either was identified with that known print or not identified with that print.
And did you have an opportunity to examine a latent print card in the case of the state of Florida versus George Zimmerman?
Yes, I did.
Your Honor, may I approach the witness?
Yes, you may.
Ms. Benson, let me show you states 183, already in evidence. Ask you, do you recognize that?
Yes, I do.
Is that a card that you examined in this case?
Yes.
And can you just kind of hold it up for the jury from where you are and just explain it to them, explain the latent card to them?
Okay, this is a latent lift card that was a area of interest was developed, and they placed a clear, or whoever lifted this print placed a clear piece of cellophane tape on top of the latent and then placed it onto the latent print card on the opposite side that you see here.
And did you examine that card to determine whether or not there were any latent prints of value?
Yes, I did.
Explain to the members of the jury how you went about that.
I used a handheld magnifier to examine the lift areas that were present on this latent lift card.
Did you find any latent prints of value on states 183?
No.
All right. Ms. Benson, did you have any further involvement in the case?
No.
All right. Thank you for your time.
Thank you.
Just very briefly. Good afternoon, ma'am.
Good afternoon.
How are you?
Good.
Do you even know from looking at that document you have in front of you where that print was lifted from?
There is a lift location that was filled out that says where it came from.
And what is that location?
The lift location says the slide of a firearm located within item TS-1.
Okay. And in effect, taken from a firearm, correct?
That's what's indicated on the lift card, yes.
Okay. And did you only get one latent print to review?
Yes, I only received one latent card to review.
And you had mentioned that environmental effects can have a negative effect on latent prints, correct?
Yes, it can damage latent print.
And I think you mentioned that rain itself can?
It can.
Because what is left as part of the latent print or the makeup of the latent print are oils from the skin?
It can be, yes.
Okay, and other debris, but it allows for the weight determination because the fingerprint can leave a minute amount of oily substance that actually is the print itself, right?
Yes.
Okay, and water can wash that away.
Yes.
So that fingerprints may have existed on an item that you would lift a latent from, and there be no latents whatsoever, correct?
That's correct.
Even though the gun's been handled by 1, 2, or 3 people.
That's correct.
Any other latent work or fingerprint work that you did have anything to do with the Zimmerman case?
No.
Great, thank you. Nothing further on that.
Okay, thank you. Any redirect?
No, Your Honor.
Okay, thank you very much. May Ms. Benson be excused? Thank you. You are excused. Council, approach for just a moment, please. ladies and gentlemen, we have some matters that we have to take care of outside your presence, and instead of having you sit back in the jury room, I'm going to go ahead and excuse you for the evening. During the recess overnight, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves or with anybody else. You're not to use any type of electronic device to get on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have your assurance that you'll abide by these instructions? Okay, thank you very much. Have a good evening. Put your notepads face down on the chair. Oh. Please be seated. Do council wish to continue the conversation at the bench? I don't know if you wanted to. Okay. Court is going to be in recess for the purposes of the attorneys until 8:30 in the morning, for the jury till 9 a.m. Court is in recess.